Good evening. Good evening. Harry, can you hear me?
Yes, I can.
Okay. Maybe I'll just move this closer. This one's not working. Okay. Good evening and welcome.
There you go. Get it closer to
The time is now 4:01 p.m. I'd like to call the August 29th and 30th and 31st, 2022 meeting of the Energy Facility Siting Council to order. Want to thank all of you for your attendance tonight. We appreciate you taking the time and we're interested in your comments. Mr. Secretary, are there any agenda modifications?
Mr. Chair, this is my. Test. Can everybody hear me?
Yep.
Okay, maybe it's the mask. Okay, so roll call. Kent Howe,
Here.
Hanley Jenkins,
here.
Jordan Truitt,
Here.
Cindy Condon, Perry Chalktoot,
Here?
Ann Byer. Mr. Vice Chair, you have a quorum.
Okay, thank you. And I jumped the gun there. And so are there any agenda modifications?
Mr. Chair, I did hear from council members earlier before the meeting that you would like to defer voting on the draft meeting minutes until tomorrow or Wednesday, depending
Right.
upon. So I guess we will defer that.
Okay, thank you. I have the following announcements. Please silence your cell phones. Those participating via phone or webinar, please mute your phone. And if you receive a phone call, please hang up from this call and dial back in after finishing your other call. For those signed into the webinar, please do not broadcast your webcam. Reminder to council and to anyone addressing the council to please remember to state your full name clearly and do not use the speakerphone feature as it will create feedback. For those testifying on the B2H agenda item, please use the raise your hand feature in WebEx to speak or press *3 to raise your hand if you are participating by telephone. You may sign up for email notices by clicking the link on the agenda or the council webpage. You are also welcome to access the online mapping tool and any documents by visiting our website. Energy Facility Council meetings shall be conducted in a respectful and courteous manner where everyone's allowed to state their positions at the appropriate times consistent with council rules and procedures. Willful, accusatory, offensive, insulting, threatening, insolent, or slanderous comments which disrupt the council meeting are not acceptable. Pursuant to Oregon Administrative Rule 345-011-0080, any person who engages in unacceptable conduct which disrupts the meeting may be expelled. So we're going to move the discussion over the meeting minutes to tomorrow or Wednesday, and we're ready for the council secretary report.
Thank you, Mr. Vice Chair. First, I have a staffing update. The last council meeting, I had let council members know that we had somebody who had accepted the rulemaking coordinator position, the operations and policy analyst 3 position, who was intending to start on August 22nd. So unfortunately, that person has elected not to accept the position and has chosen to pursue something else. And therefore, we have reinitiated the recruitment process for that position. In the meantime, Christopher Clark will continue to serve as the rulemaking coordinator as he has in the last several months. So he'll pull double duty, being a siting analyst as well as a rulemaking coordinator. So he'll continue to move forward on the rulemaking projects as well as the assigned projects that he's working on. So, and we thank Chris for his efforts on that. Next on my list are project updates. So on August 7th, the notice of intent for the Bonanza Energy Facility expired. So once a notice of intent is filed by an applicant, they have 2 years within which to submit a preliminary application. Prior to the conclusion of that 2-year timeframe, they can also submit a request for an extension for 1 year to extend the notice of intent by 1 year, which means extending the ability to submit the preliminary application for site certificate for 1 year. Bonanza facility failed to either submit a preliminary application or a request for an extension. So that facility has expired, or at least that notice of intent has expired. And the facility was proposed at 150 to 300 megawatts. It was a solar energy project with up to 1,100 megawatts of battery storage, relating and supporting facilities. The project was proposed to be on 2,700 acres, so 4.2 square miles. It was to be located in Klamath County near the town of Bonanza. And the applicant was Hecate Energy Bonanza LLC, which is a wholly owned subsidiary of Hecate Energy NAF LLC. They have indicated their intention to resubmit a notice of intent in 2023, so we'll wait to see if they do that. Second on my list is the Oregon Trail Solar project. On August 19th, 2022, we received a request for amendment number 1 for that facility. That amendment request includes 2 individual requests. The first is to extend the beginning construction date from August 30th, 2022 to August 30th, 2025. So they did not construct the facility within the timeframes originally approved, and they're requesting a timeframe extension for that. And then the second request is to revise condition 50 sub B to eliminate the requirement of a cultural resources monitor being present when ground disturbance occurs at depths of 12 inches or greater, to requiring cultural resource monitor being present when there is the initial open ground disturbance below 12 inches associated with collection line trenching in the solar array. So that's a little bit nuanced, and so I just wanted to throw that out there so you're kind of aware of it, but really it's about sort of the presence of on-site cultural resource monitors during construction. They're requesting a change to that. They've also requested a type B review. The facility is approved to include any combination of wind and solar components not to exceed 41 megawatts, including up to 16 wind turbines, or up to 1,228 acres of solar PV generation equipment. And the entire site boundary is approved at 13,800 acres. The facility was originally part of the Montague Wind Power Facility, but was split off from that facility through amendment number 5 in September of 2020. That's why it, when I described it, it's a rather small facility. It's because originally it was part of a much bigger facility, and then they split the site certificate into 3. The applicant, the certificate holder is Oregon Trail Solar LLC, which is a wholly owned subsidiary of Avangrid Renewables LLC, which is the U.S. division of the parent company Iberdrola. And I have one, unless the council has any questions on either of my project updates, I have one more update. So there is a group called Verde, which is currently working with Renewable Northwest and Thousand Friends of Oregon, and they just began pulling together a comprehensive stakeholder, they've called it a table, but essentially, you know, a group of diverse individuals and representatives from different areas to discuss the siting process in Oregon. And I'm quoting from their information, how to address some of the frictions that are coming up between communities and developers, and whether there are any changes that may be needed in the system to help address new policy goals, such as those established in House Bill 2021, but also to protect community self-determination. So it's a pretty diverse group: developers, the public, interest groups, state agencies, other natural resource groups. So it's a fairly large group. So just so I you have some understanding, Verde, the entity, their website states that its purpose is to serve communities by building environmental wealth through social enterprise, outreach, and advocacy. So that's really the head of this group. The group met on August 19th. It will again meet on September 2nd with additional meetings planned through the fall. The idea of the work group, as we understand it, is to seek input from a broad group of stakeholders in order to identify potential legislation for the 2023 session. The near-term goal is to have a placeholder study LC legislative concept submitted on September 23rd and spend time throughout the fall working to identify what should be included. There are legislators who are part of this who have been engaged, including Bayfield, Representative Marsh, Representative Brock Smith, Representative Owens, Representative Helm, Representative Pham, Representative Levy, Senator Lieber, Senator Finley, and Senator Dembro. If any council members would like to be included, invited, it's not our group, we're not the lead, but if anybody's interested in tracking or being invited to that, we can reach out to the group leaders and see if we can get an invitation extended to any council members who are interested.
Todd, just a question about Verde. Do they have experience pulling diverse groups together? Do you know? I mean, is this a common practice for them?
I think so. I don't personally have much experience for them, but that's my understanding is that's kind of what they do. They're kind of more of a grassroots organization seeking kind of broad input. So that's my understanding.
Okay. And a follow-up, if I may. Is there anybody from the department
Yes,
involved?
the department has been participating so far.
Thank you.
Okay, Mr. Vice Chair, with that, I will conclude my secretary report.
Thank you, Secretary Cornett. The next item is the Boardman to Hemingway transmission line. At the last meeting in July, the council reviewed the standards from the proposed order that did not result in any contested case issues. This August meeting, the council reviewed the standards from the proposed order that did result in contested case issues. We have Kellen Tardyweather, Oregon Department of Energy Senior Siting Analyst, and Jesse Ratcliffe, Senior Assistant Attorney General, Natural Resources Section of the Oregon Department of Justice, presenting and walking us through those standards this evening. So with that, I'll turn it over to Mrs. Tardyweather.
Thank you, Vice Chair Howell. For the record, my name's Tardyweather, Oregon Department of Energy. I am trying to share my screen. So, and normally through all of those introductions, we would have had a PowerPoint and a screen corresponding with all of those, but I'm having issues sharing my screen right now. So 1 minute, if we may, while we just try to troubleshoot this, and I may have somebody else just share until I can figure this out. Thank you. Where on are some, I want to be to cover. So I just, we're announcements. I have the PowerPoint on my screen and we're going to work on getting it up on the screen here. So thank you for being patient. This is the introduction and here we are. So I'm going to do, and I know it's easier to have the visual representation, but I'll just do it orally just to kind of get us going here. I do want to, again, Kellen Tardyweather, Senior Siting Analyst, Oregon Department of Energy. I'm up here with my colleague, Sarah Esterson, Senior Policy Advisor. We've been working on this project together for the duration of my time at the department, which is 6 years. However, that is a short time compared to some of the folks that have been working on this project. Boardman to Hemingway transmission line from Idaho Power over here in the room. They've really spent a lot of time. Equally as much, I'm just going to turn around and thank all you folks for showing up here tonight and welcoming us to LeGrand. And I know that a lot of you have spent over a decade following and participating on this project, and we really appreciate it. That time and you all being here. So just, and I'm sorry that my back's to you, but we can see you up here. So I'm just going to do an overview of what we're going to cover today. And then once we get it up, then we'll just kind of catch up. Is council comfortable with just me proceeding without the visual cues? Okay. The PowerPoint is also available on the department's webpage. So council can also kind of pull that up and go with it. Now, it might be a little bit different because we've, just kind of rearranged some slides or done some edits. So the version may be a little bit different. So today we're going to continue with council's review of the proposed order for the Boardman to Hemingway transmission line application for site certificate. I, as staff at Odo, who are also, and the department is party to the contested case, which we're here today because the contested case has concluded and now the ball is back in council's court. So I'm going to be doing a presentation of the information in the proposed order to the best of my ability and to the extent that we can separate it from a contested case related issue. I'm going to be going over that information. And then council will have an opportunity to deliberate, ask questions, and offer any changes to the materials that are generally unrelated to a contested case issue. And then Jesse Ratcliffe, council's counsel, is going to take over and do an introduction of the contested case issue. He'll provide an overview and any variation of it, and kind of the format may change depending on the complexity of an issue or the amount of information submitted on an issue. But he's also going to provide an overview of the that issue and what the hearing officer's proposed contested case order said, and then we'll go into exceptions filed related to that issue as it's framed in the proposed contested case order. And then there was also the opportunity to file responses to those exceptions to the proposed contested case order. So that's what we're going to be covering today. And then after that, council will then have the opportunity to deliberate, ask questions, make any modifications to the proposed order or to the proposed contested case order. Yeah. And then Idaho Power, we understood that Idaho Power contracted with a court reporter. Can we get confirmation either in the room or that court reporter's online? Okay. Oh, can we put her as a panelist? Do you have her name? Crystal, okay. We want to make her a panelist because if somebody needs to repeat or slow down, or if people are talking over each other. Okay. Okay. And then Crystal, do you have the opportunity to chime in whenever you need? Is it? Okay. Thank you. That's, it also, my microphone. Is that better? Okay. I was gonna, if you guys could hear me. Okay. I generally yell talk anyway, so it's not a problem. We'll try to remind ourselves to all, use our microphones. Okay. So we still haven't heard from Crystal. I do want her to be able to have the opportunity to chime in. Maybe you, Crystal, if you can hear me, maybe you can. Okay. Okay. Okay, Crystal, you can unmute yourself.
Can you hear me now?
Yay, there you are. Okay.
Okay.
Okay, great. So that works. So Crystal, as you're documenting the goings on here, please feel free if something is unclear, just chime in since you're remote, feel it free to interject to get clarity on whatever you need for a good transcript of these meetings. Okay, so after Jesse Ratcliffe goes over his items, council will then have the opportunity, questions, deliberations, modifications with the basis, and then we'll do a straw poll on those items as well. And we still can't see we're still working on the presentation. So, okay, I have a very on the presentation, I have a very familiar chevron diagram of the major process steps, and I just kind of wanted to go over where we're at today. I wonder if they could just pull up. It's just hard to do a presentation without everybody seeing it. Should I just keep on going? You guys got it on the screen?
See if we can all.
It's not going to work. Mine needs to be a lot. What, 1 minute? Apologies. Okay. Okay. All right. We're back on. So, some of these slides are going to work well. Some are not. I generally set up my presentation to have some animation. So some things may be covered up. So just bear with me. We are on slide 8, Nancy. So kind of going back in time, in July, we began council's review of the proposed order. Now, but for the issues that are not related to the contested case, but I'm going to touch on that in a little bit. I'm not going to spend a lot of time on this, but this is we have these series of meetings because we're kind of bundling a lot of parts into these meetings. The department held a series of meetings on the draft proposed order, on the hearings. After those, we issued the proposed order. It was in red line format because those red lines demonstrated or it was a way to highlight how the department and the applicant responded to the comments that the public and agencies provided on the draft proposed order. So that's why the proposed order has those red lines in it. And then that proposed order is what went out and folks had an opportunity to request a contested case if, and it basically just kind of summarizing that if their issue was not appropriately addressed or how, that they thought in the proposed order, then they could raise it in their petition for a contested case. And then there was the contested case and then there's the output of that contested case was the hearing officer's proposed contested case order. And so before council gets to this final order and site certificate or final order and final decision, we kind of have to go back in time for council to understand everything that that came out of that contested case proceeding. But it also, council hasn't seen the proposed order because the last time council had this project in front of them for, deliberation, input, modifications was at its review at the draft proposed order. And council looked a little bit different then. Some folks were there, some folks weren't there. Council did offer revisions and edits to conditions and items at that time, and those are also reflected in that proposed order. So this is where we're at today. Nancy, next slide, please. Okay, not going back in time. This is kind of a date by date summary of the recent history. We are going forward from 2010 and 2012. This is just to give an idea of the bigger milestones towards the end of the contested case. The contested case lasted quite some time. The contested case itself had a lot of deadlines for all participating individuals and opportunities to respond to those deadlines and filings and motions and responses. And it itself was a very time intensive, labor intensive process for the Department of Justice, Idaho Power, but also for the members of the public and their representatives participating in the contested case. This is where we're at now. Okay, next slide. I love talking, so I'm just going to try to cut myself off and move forward. But as per usual, council, if you have any questions, please, or want me to slow down, just let me know. This is important. We just wanted to let folks know council has received items in electronic versions and also in paper copies. Council does have a very large binder, which those were very hard to put together. So sorry, I was lots of crawling around on the floor. It's okay. We did it. But it is in the format of the agenda today. So we understand that there may be some rearrangement or jumping around. We're going to do our best to stay on time, go with the flow. That said, those timeframes in the agenda are total estimates on how much just approximately we think it may take to go through that agenda item, which includes my part, Jesse's part, and council's part, and any oral testimony on it. So we're really just doing our best to get an idea of the schedule there. But council has received those items. We're going to do our best. And if council needs help finding in your binder where something is, or if you're using the electronic PDF, then we can help assist you. However, they are in the format of the agenda. And council has had those for a while. Next slide, please. Now's when I do. Okay. So, in July, I feel like The proposed facility, as most are aware, is predominantly a 500 kilovolt transmission line. However, the proposed facility, and according to council's definitions, a proposed facility is the energy facility itself, and including all related or supporting facilities proposed by the applicant. So it's predominantly of a 500 kilovolt transmission line. However, there are some rebuilds and removals of other transmission lines. There's also a substation and communication stations and systems. I don't have a slide for this, but and we talked about these. I went into more detail primarily to update and familiarize newer council members, council member Choctu. I'm sorry you weren't there in July, but I'm sure you've been looking at these materials. But I basically just gave a bigger, more detailed overview of the related and supporting facilities and the proposed facility, including like the transmission structures, et cetera. So the related or supporting facilities associated with the Boardman to Hemingway transmission line are a series of roads. Roads are very important. At the July meeting, we talked about how the applicant defined roads as using the council's definitions of substantially modified as a way of deciding whether or not those are technically proposed by the applicant and included in the application, is whether or not that they would be modified, needed to be modified for construction or operation of the facility. And there's also new roads as well. There's also multi-use areas, polling and tensioning sites, as well as some multi-use, some of the multi-use areas and polling tensioning sites do have helicopter operations that could function out of them as well. So, sorry. Oh, so that's the proposed facility. The applicant requests, and council's very familiar with micrositing corridors. A micrositing corridor is an area that is evaluated within the site boundary where that if approved, an applicant could place any of the facility components in that area. For this facility, the applicant's requesting that the site boundary function as the micrositing area. So they have a larger site boundary to where that, well, let's just, for the example, the transmission line, the site boundary for the 500 kV transmission line is 500 feet. However, the anticipated final right-of-way is going to be 200 to 300 feet. And so that means that they could move it around to microsite around resources or minimize impacts within that larger site boundary / micrositing corridor. So the final right-of-way will be lesser than the actual site boundary. We'll talk about this later on, but the right-of-way and forested areas is 300 feet, which is larger than, say, across like EFU zone lands, and that's to make sure that there's adequate clearances for vegetation and trees. Next slide, Nancy, please. I noted that there are some alternatives on this slide. I really want to remind council that the council's process is different than the federal NEPA review, which may result in the lead federal agency offering, recommending, or imposing alternatives that are not necessarily proposed by an applicant. That can be an outcome of the federal review process, but that the council does not have the authority to have that be an outcome. Statute tells council that you're approving or denying an application for a site certificate. So what is proposed by an applicant is what is in the application, and the question that's in front of council is whether or not those routes, all the routes meet or don't meet applicable council standards. And it is possible that an outcome is that maybe one or two routes do, but maybe another alternative doesn't, or they can be conditioned differently. That said, in the proposed order, the way it's framed is that under the standards, say the Fish and Wildlife Habitat standard, we talk about all of them together. So all of your temporary and permanent impacts to fish and wildlife habitat for the proposed route, and all of the routes are talked about in its totality unless there was like one area, for instance, there's Washington ground squirrel only really occur in, this one area in Morrow County where there are some of those alternatives. So some of these conditions would really only apply to those and not necessarily to a route or an alternative route that cross Malheur County. Next slide, please. Okay, so these are the standards that we talked about in July and that council, discussed, did straw polls. What I wanted to take a minute and pause on this, which we talked about in July, is that we did go over the general standard of review because underneath that standard is where there were like construction deadlines, some mandatory conditions. But I told council we're going to revisit general standard of review. The general standard of review, and if council looks at the very last page of your order, that is the general standard of review is the standard that says, does the preponderance of evidence on the record demonstrate that the applicant, can meet the applicable council standards, as recommended in this order. So really, under each standard that we talk about in the next several days, just in the back of council's mind, you're looking at the language of the standard, and then you're asking yourself, and so I also talked about what the preponderance of evidence is. And so I'm just going to read this. The proof by preponderance of evidence means the greater weight of evidence, and that facts asserted are more probably true than false. Thus, to issue a site certificate, council must find that the evidence on the record demonstrates that it's more probable than not that an applicant will comply with applicable standards, statutes, and administrative rules. So as we go through this, council, ask yourself, okay, I see the standard, and then asking, is it more likely than not that the applicant, in the language of the standard, that the applicant that it's likely that with mitigation, language of the standard, is it more likely than not that they could meet that? So general standard ultimately is what council's going to be making their final decision on, but it does include all of the other standards. Okay, and I am going to pass it off to you, Mr. Ratcliffe. Next slide, please, Nancy.
Okay, I just want to make sure that is coming through. Okay, thank you, Kellen. Vice Chair Howe, members of the council, for the record, my name is Jesse Ratcliffe. I'm an Assistant Attorney General with the Department of Justice, and my role here today is to advise the council in legal matters and getting through this process. Patrick Rowe, my colleague, has been involved in this application heavily for quite some time. It has been the practice of the council and the Department of Energy staff for a number of years to have separate attorneys representing the council and the staff once we get to a contested case phase. That is not required under Oregon law. However, it is something that has been a practice for quite some time. And that is the reason why I am up here presenting to you instead of Patrick. And so, I think at the bottom, my role is to be a resource for all of you. I don't define the processes that we're going through here, but I am here to be able to answer questions, and I will, on the contested case issues, I will kind of kick things off by giving a summary of the issue and what the hearing officer decided before we hear the oral testimony from folks who have filed exceptions and from any responses that parties may want to make. Again, Kellen walked through how we got to where we are today. And since my role will be dealing with the contested case issues, I just want to briefly talk for another minute or two about what that contested case process is. It is a sort of mini trial, a somewhat less formal trial that, with all the kind of ideas that you might have about that, in terms of the ability to introduce evidence, to provide testimony, and to have an independent hearing officer make a decision on the issues before her. And so that's what has happened here. We've gone through a lengthy contested case process with a significant number of issues and a significant number of parties, taken a lot of testimony, and the hearing officer has reached her decision on those issues. At the same time, there's all the substance that comes in. The purpose. Sorry, I'm going to really have to lean close here. The purpose of the trial fundamentally is to take substantive evidence. So if we have a fish and wildlife habitat issue, that we get evidence and testimony in pertaining to that issue. But as with all trials, there's also a fair bit of procedure that goes along with that in terms of the way in which that testimony can be taken. Benchmarks for the reliability of that testimony, deadlines that need to be hit so that it remains an organized process. So the first thing that I'm going to be doing here today is, after I conclude this kind of introductory section, is to talk a little bit about some of the procedural exceptions that were filed in this case. Concerns about not the substance of has the applicant met a particular standard or not, but under the rules and statutes that apply to the hearing, to the contested case hearing, were they followed appropriately? I'll be getting into that in just a second here. The last thing I want to talk about before I do that is the process that we have set up. This is taking place in an open public meeting. Ordinarily, or commonly, when anyone asks their attorney for advice, and I am your attorney for this process, it is subject to confidentiality. That's the attorney-client privilege. The counsel, as my client in this process, can choose to waive that privilege. And typically, that is what has happened in processes that I've been involved in and serving in this role in the past few years. It is not required. It is also not my choice to make. If at any point the counsel decides that they want to hear advice from me that is, for your ears only and is subject to privilege, what I will need you to do is have someone, raise their hand, let me know, hey, I've got a question. I think that this may pertain to the particular risk of making a decision this way or that way, and how that might play out on appeal. And then we'll kind of stop for a minute, talk about what options are, and whether or not that is something that a particular piece of advice gets delivered outside of the public meeting. And again, even though the general practice of the council at least the past few years has been to do this all, for the most part out in the open, we have had instances where that has been the council's choice to do that, and that is a very common practice with other boards and commissions to be able to take advice outside the public meeting. But that is, a component of what my role is today, is to, provide the sort of advice that might ordinarily be privileged. So with that, I think that kind of covers what, my role is, how this process is going to take place. The first set of issues that I want to get into, again, are the procedural ones. And this is going to immediately bring up a process point for the meeting, because on the substantive exceptions that were timely filed, the proposal on the table is to allow the parties to have oral argument time on their exceptions. The idea with that is really, by and large, the exceptions process is on paper. And in complex cases like this one, that makes good sense. You're, having the party has the best opportunity to, get their thinking down in writing and present that to the council for review. However, it is permissible, and the proposal on the table is with respect to the substantive issues to allow the both the party who filed the exception and then any responding party, either the Department of Energy staff or Idaho Power, to have a short period of time to kind of highlight some of the issues that they want to in oral argument. The proposal is for that to be a 3-minute period for each acceptor. Some issues will have more than one person who's filed an exception. In that case, each individual person who filed an exception will have their 3 minutes to talk. And then similarly, the Department of Energy staff and Idaho Power would have 3 minutes. That time, and we have had a couple of requests, which I've forwarded to you all, to extend that time. That is at your discretion. Of course, the additional time is additional meeting length. We do have a lot to get through, but that is something that the council could take up if it wants to. On the procedural issues, the proposal is not to have oral argument on those, to focus on the paper, the written exceptions that were filed. And the reasoning in part is because we do have a lot to get through. And fundamentally, the process here is to determine whether or not the applicant has met the substantive standards before you. But again, I want to go ahead and set this out in case any council member feels like there's need for discussion on, the proposal of how this is going to work in terms of discussion of the contested case issues. If there's a need for discussion on that, I will turn the floor over and we can have that discussion. Otherwise, what I'll do from here is move into the procedural exceptions that were filed.
Comments from council that you want to discuss before we move on into explanation of the procedures?
This is Hanley. I support the proposal for the 3 minutes because we have a lot of exceptions and responding parties. And so.
Also in agreement with that, we have all the written testimony and there's no new information that can be submitted. So, and they've had opportunity for their oral comments back when we were here 3 years ago on the 4 meetings that we had, as well as before the hearings official. And so I think the 3 minutes is adequate for them to emphasize anything they want to bring our attention to in the written comments that we have, and no new information can be provided anyway.
Just so the public understands, we do have these amazing books full of your written testimony, and we were allowed to get these in time to get through them. So I think the idea to really, in your oral testimony, highlight what you want us to hear would be very helpful. And a shout out to the Department of Energy staff for the amazing production effort to get these materials to us in a timely manner. But just know that we take this, we have a responsibility here, and we were given the tools to really dig into your testimony. So think about how you want to summarize it for us and hit those high points. Thank you.
Any other comments? Okay, we're ready to proceed.
Okay, and speaking of that very fine binder, which we will be speaking about a lot over the next few days, the place where the procedural issues are to the front of the materials, and it looks like a couple of you have them in separate binders, which is great. And the we had procedural challenges that were specifically filed by Stop B2H and Irene Gilbert. And then we also have a couple of challenges aside from that that are objecting to how a particular contested case issue was framed by the hearing officer, which again is itself a procedural issue. The hearing officer has is in charge of the hearing, including the the definition of those issues. So I am going to be doing a little bit of jumping around here. I apologize for that, but there are a number of issues that were raised by both Stop B2H and Ms. Gilbert. And as a result of that, I will, to kind of keep things organized that way, need to be moving back and forth a little bit. So the first of these issues that were covered by both Stop B2H and Ms. Gilbert has to do with the type of party status that was granted to folks who are participating in the contested case. And the council members may recall that we had extensive discussion of this and a decision by the council on this issue previously. But just as a reminder, and for those in the room, that is the difference between what's referred to as a limited party under the council's rules and the Oregon Administrative Procedures Act, and a full party. The basic concept here is that the limited party has the ability to participate on the specific issues that they timely and appropriately raised, rather than coming into the contested case process and sort of participating on anything that they see fit at that stage. The council's decision came about because a number of parties earlier on in the process, after the hearing officer had made her initial decision on party status, a number of parties appealed those decisions to the council, which is provided for in the council's rules. For the most part, the idea is we try and get through the contested case process without bringing it to you. But there are a couple of exceptions, and that is one of them, to hear appeals on the definition of the issues, and in this case, on the nature of their party status, whether they're full or limited parties. So the council heard extensive arguments on that and reached a decision that then has carried forward through the rest of the contested case, which is that if a party raised an individual issue in a timely fashion on the record of the draft proposed order, raised that with sufficient specificity, then that party has the ability to continue forward with that issue. If they raised multiple issues that got in, they can participate in multiple issues, but the parties were not kind of allowed to cross over into other issues that they themselves did not raise. So both Stop B2H and Ms. Gilbert have filed written exceptions to that, raising a number of the arguments that had been heard by the council at the earlier stage. And so, again, this will be the first time that I'm doing this, but, as part of my role in this process, it's to give the council a read on where you stand legally. So if this were taken to the Oregon Supreme Court on an appeal of a final site certificate decision, how would you be looking on that issue? On this particular issue, again, this was the subject of extensive briefing and also my advice, which hasn't changed from that period of time, which at the time was that the statutes and rules allow the council to provide for this limited party status. And so the hearing officer's approach to doing that and the council's affirming that decision by the hearing officer are procedurally appropriate. And so what I'm going to do on each one of these is essentially just this, a little, a bit of a highlight, a summary of what's come before on the issue, and then where things stand legally speaking. And so I'm going to stop on this one and see if there are any comments, questions. I'll answer those. What I'm going to do after that then is keep going through these procedural issues. I'm going to be taking notes if you have questions, comments, concerns. Once we get to the end of this process of me walking through these procedural issues, if it appears that there are things that we need to cycle back on and potentially look at the idea of making changes on to the proposed contested case order, then we'll bring those up, and we'll end up with kind of a straw poll, which is, again, not a final decision. It's the sense of the council right now as to where we stand on those issues. So with that, I will stop talking here for a minute and see if there are any questions specifically on this limited party status issue.
Doesn't look like there is.
Okay, so the next issue that I'm going to go to is one that was raised by Ms. Gilbert, that is the compliance with a statute under the Oregon Administrative Procedures Act. It's Oregon Revised Statutes 183-470 sub 2. And the contention in the exception is that this procedural statute hasn't been complied with. And the statute itself deals with the final order in the contested case. The statute that she references states that a final order shall be accompanied by findings of fact and conclusion of law. It goes on to talk about, what those findings of fact look like. And the key point here in response is that we haven't reached a final order yet. Ms. Gilbert's absolutely correct that every final order that's issued by a state agency needs to meet this. Before all is said and done here, no matter what the outcome of the site certificate decision is, a final order that meets those requirements will need to be prepared. The department staff will assist you in the preparation of that. And so we will get there, but we're not there yet. So I don't have anything else on that. But again, we'll pause for questions.
Questions from the council? None so far.
Okay, the next issue that I want to talk about is one that was raised by Stop B2H. And this exception concerned the timeliness of the filing of recommended conditions. And so one of the parts of the process that is specific to the council statutes is the ability of parties thank you. To raise the need, as far as they see it, for a specific condition that the site certificate should include. The hearing officer had made a statement in the proposed contested case order that was not accurate entirely on this issue. This is one where my recommendation is that the proposed contested case order should be corrected before we get to a final order. And that's to acknowledge that all conditions that were proposed by the closing argument deadline were timely and should be considered. So what the hearing officer had done is excluded some of those proposed conditions as untimely. Now, if she had stopped there, the council would have more of a lift on this procedural issue, because we would then need to be talking about what each of those conditions were, how to address the fact that they were excluded. Fortunately, the hearing officer went on to consider the merits of those proposed conditions anyway. So while it is an error on the hearing officer's part to have said that the proposed conditions should be excluded from the process, she considered them anyway, and this then becomes a kind of a technical fix to the proposed contested case order to acknowledge that they were in fact timely, and that the hearing officer did in fact choose to consider them. That's all I have on that one.
Questions or comments?
This is Hanlon. Sure.
Okay.
Okay, so the next procedural exception, this is one raised by Ms. Gilbert and is referring to hearing officer decisions on discovery and witness cross-examination. So these are two of the trial type procedures that get used in a contested case. Discovery is the ability to ask another party in the case for records that are relevant or may lead to relevant information. There's a set of rules that govern that discovery process. Similarly, the ability to cross-examine a witness is fundamental to trial-like procedures in the United States, both in courts and administrative proceedings. So that's a component of these hearings. So on this particular issue, having reviewed this, the argument is essentially that certain witnesses did not adequately respond, or potential witnesses, I guess I should say, potential witnesses did not adequately respond to discovery requests that were made of them. And therefore, there was a request to cross-examine those witnesses. This one gets a little bit technical, but there is a process for compelling discovery if party feels that was not adequately responded to, and basically the request for a witness to appear for cross-examination wouldn't be the appropriate next step in the process. We want to work through these issues before we get to the hearing, and so that's what would have needed to have happened. And so the hearing officer's decision fundamentally to say, well, this isn't the right remedy here to have this person show up for cross-examination. We would have needed to see more of a demonstration of precisely what it was that was not provided, and why that should have been provided. Having looked at that, my recommendation is that the hearing officer handled that one correctly.
Is there questions? You can continue. Thanks.
Sure. Another procedural exception filed by Ms. Gilbert pertains to the hearing officer's filing requirements and her method for managing the record. Ms. Gilbert had proposed a different system for referring to documents in the contested case process. The hearing officer declined to adopt that. It is a part of the hearing officer's responsibilities to manage the record. I freely acknowledge having been involved as an advocate in cases of this size before, that you know, it's a challenge. And whatever ends up getting picked is you're still going to end up running into difficulties with. However, what the hearing officer did was use a commonly accepted means for managing a record of this size, requiring kind of a uniform, process for referring to documents. And so that decision is fundamentally something that's within the hearing officer's discretion to figure out, and and she chose an appropriate method. Okay. Just let me scroll here for a second. So we have a related exception from Ms. Gilbert that points to a statute that requires the hearing officer to conduct a full and fair hearing. And that reference shows up in Oregon Revised Statutes 183, 615. And this ties back into an earlier part of the contested case process where Ms. Gilbert had filed a motion requesting the removal of the hearing officer. That was something that was taken up by the council, and the council decided not to remove the hearing officer. That motion contained a number of similar objections. The full and fair hearing, as you can tell kind of by the phrasing, it's not a particularly specific requirement. Under Oregon law, has included certain baseline requirements, and a lot of those are the processes that show up within the hearing: an opportunity for discovery, taking testimony from witnesses, the filing of exhibits, that sort of thing. And the council's rules helpfully here actually do provide a little bit more illumination on what that looks like, because they spell out what the duties of the hearing officer are. And the hearing officer, has hit each one of those duties throughout the process. So again, at the time, the council decided not to remove the hearing officer, that she was providing that opportunity for a full and fair hearing. One more related one on that note is an objection by both Stop B2H and Ms. Gilbert as to the format of the proposed contested case order. So having gotten through, the earlier trial type procedures, we got to the point where the hearing officer wrote the order. And again, as I referenced earlier, Ms. Gilbert's citation to a statute requiring that there be findings of fact and conclusions of law. Again, that is absolutely a requirement. However, the formatting of how that gets done specifically is left to the discretion of the hearing officer. The hearing officer here did include extensive findings of fact, use those to support conclusions of law. Now, many of her findings show up in the opinion section. So, she frequently has listed some of the evidence that was entered into the record as part of the hearing, and then ends up weighing that as she discusses how she is ruling on a particular issue. That's not the only way of writing a proposed contested case order, but it is an acceptable way of doing that. So my recommendation on that one is that again, she chose an acceptable method. Okay, I have just a couple of these left to go here, and just want to make sure that I'm taking them in an order that roughly makes sense. Okay, so the next one has to do with an issue that the council has similarly heard about a number of times throughout this process, filed by Ms. Gilbert, and that pertains to the rules that are used in this process. And so this is one that the council has heard before, so I will try to make this short, but basically, several years ago, the council determined that in order to get consistent, high-quality hearing officers to hold these contested case hearings, the historic practice had to been to, do RFPs, basically, to go out and find an independent contractor to hold the hearings, because we had run into issues with a couple of hearing officers by that method. What the council then decided to do was to shift over and start using hearing officers from the Office of Administrative Hearings, which is the state body that holds most of the contested case hearings in the state. As part of that, though, there is a technical issue where any agency that chooses to use those hearing officers from the Office of Administrative Hearings ordinarily has to use the rules that the Attorney General's office provides as sort of a standardized process. That has a number of exceptions, though. There are a number of agencies whose application processes are unique enough that there's an exemption from the use of the Office of Administrative Hearings, and therefore an exemption from the use of those rules. The council is one that the legislature decided should be exempted. And for that reason, when the council nonetheless decided to use the Office of Administrative Hearings for hearing officers, there was a request made to the Attorney General to have an exemption from that rule and to allow the council's rules, which have historically been applied to every application that has come before the council, to continue to have those rules apply. The Attorney General granted that request. Ms. Gilbert has objected to the continued use of the council's rules instead of the Office of Administrative Hearings rules. And the main point here is that the exemption decision, while requested by the Department of Energy and the council, is ultimately the Attorney General's decision. An objection to that decision would be made with the Attorney General. And at this point, that's not really within the council's jurisdiction. Once again, just to be clear about this, the rules that, as a result, the rules that have been applied in this contested case process are the same rules. They're the council's rules that have been applied in every application that has come before the council before. So then we have a number of issues where folks have filed exceptions that were based on the way that their issue statement was framed. That is included as a part of this initial presentation because the council has already considered how those issue statements were handled, but because folks filed exceptions on these, I wanted to at least bring it to the council's attention that there are some folks who maintain their objections to the way that the contested case issues were framed. That includes Michael McAllister. Mr. McAllister's exception is to the dismissal of his issue earlier on in the proceeding that argued that the FSEC review must be consistent with the Bureau of Land Management's NEPA review, the National Environmental Policy Act. That issue was dismissed because basically because the council is bound to follow its own statutes and its own rules, not separate federal statutes. This was addressed on the appeal to the council on issue statements. And, you know, while there is a council statute that encourages the council to work where possible with its federal partners, that only goes so far as the law allows. The council doesn't have authority to say adopt NEPA. There's no authorization for that. So that's the basis for that dismissal. The remainder of these filed by Ms. Gear, contending that there were incorrect summaries of Fish and Wildlife 3 and Fish and Wildlife 6. Ms. Gilbert, pertaining to issues NC2, HCA 3, and part of Fish and Wildlife 3. And then and Kevin March, pertaining to Fish and Wildlife 7. Again, each of these objections were heard on the appeal to the council earlier on. The parties maintain those objections, but again, the council has ruled on them. So that is a lengthy list. I apologize for the amount of time involved in that, but that's is necessary to walk through each one of those. So unless there are any other questions, what I'd like to turn to now is just simply a very basic straw poll to get the sense of the council as to whether anything that you've heard so far bears correction of the proposed contested case order or requires any additional process other than what we're going through over the next few days. As a reminder, the one change as I went through the procedural exceptions that I do recommend be made is that the proposed contested case order be corrected to acknowledge that all conditions proposed by closing argument deadline were timely and you know, and that these ended up being addressed by the hearing officer. That's the type of correction to the proposed contested case order that should the council decide to pursue that recommendation, that then staff can turn around and prepare for you to look at the following meeting.
It's up to this point.
So just, yeah, this is Hanley. Jesse, how do you want us to do the straw poll?
Yeah, so I think, you know, what I'd like to hear basically, and these can be very informal, you know, there's no particular motions that need to be made or anything, but, you know, a council member can simply, you know, raise their hand and say, you know, it's my view that here's what I think we ought to do. And, you know, we can go around and see folks can raise hands or however they want to handle it. And then if there's anything that seems to generate discussion from that, if we have, you know, if we don't have unanimous consent and a council member wants to make a comment, then great, we'll take the time to do that. But the overall point here is that this is informal because we're not making a final decision. We're just trying to get a sense of where we're at now.
Okay, so thank you, Mr. Chair. So I agree with your proposal for the one change and on the other issues. But if someone has some discussions, I'm happy to entertain that. Thank you.
And if
This-
council members would like, I can call roll. So there's a formal
Okay.
on the record. If that's your, but as Jesse said, that's entirely your choice.
What's the council druthers here? Do a formal roll call? Yeah, okay. And I'll go ahead and say, Mr. Ratcliffe, that all the filings on the procedural issues, I'm in agreement with the way they've been dealt with in your statements that you walked us through right then. So I'm comfortable with that.
Okay.
Condon, and I also agree. Thank you.
Ann Meyer, and I'm also comfortable making sure we catch the nuance on the change you're recommending, that it's not the exceptions, help me.
Yeah, so these, and there's a lot of jargon here. And so this is the conditions, the
The
proposal of
conditions
conditions.
were timely filed and that the hearings officer considered them. I think that's important to show in the record. Thank you.
Jordan Truitt, I agree with our fellow council members.
Counselor Choptic,
I also agree.
thank you.
Okay, thank you, Vice Chair and council members. And so with that, I'm going to give my voice a break and turn it back over to Ms. Tardy-Weather.
For the record, Kellen Tardy-Weather. Nancy, will you go to the next slide? Jesse, I'm not sure if you wanted, this is like an overview of where there were, anyhow, I'm not sure if there's anything you wanted to say on this slide.
Yeah, so I guess the only thing that I will point out here, and thank you, Kellen, is that we did have a number of issues where no exceptions were filed. And procedurally speaking, the council members are welcome to have discussion on any of these issues, but generally speaking, the way that decision-making bodies will kind of look at things is to say, well, we've gotten through the contested case process. The hearing officer made a decision, a proposed decision. If parties continue to have objections after that decision is made, the expectation that the best way to approach that is to, and legally provided for way to approach that is to file an exception. So absent an exception being filed, the general thought is that, well, okay, we may no longer have a live issue here. This may have been adequately disposed of in the contested case. And frankly, that's, it's kind of the hope going through, is that you start narrowing down on the issues. So this slide talks about issues that were either dismissed on summary determination by the hearing officer, or that were, included in her proposed contested case order, but no one filed exceptions.
Questions from council on the 25 issues that were dismissed on motion for summary determination?
So do we need to do a straw poll on those? Mrs. Hanley.
That's entirely up to you. If you would like to, that's fine. If, again, this is kind of however you would like to do this one. I think the main thing is that the staff and I need to know, by the end of the process where the council is at. So if there are any changes to the proposed contested case order that need to be made, or any additional process that we need to go through, that we know about it. So, if you would like to hear more about one of these issues, great. If everyone's comfortable with where they're at, you can speak up and we can go from there.
Yeah, I'm fine with 25 that Kent mentioned. Issues that were dismissed.
Not hearing any other comments from any of the other council members, then I think the position of the council is that we're okay with those 25 issues dismissed, unless Mr. Choptic, do you have any concerns, questions?
No, I do not.
Okay.
And sorry, I apologize. Before we move on, I just I believe that there may have been a typo on this. We have one issue that actually will be showing up in the exceptions process, an exception that was filed, and that's SR6. So I apologize for that.
Okay. Thank you, Mr. Ratcliffe. For the record, Kellen Tardy-Weather. Nancy, we go to the next slide, please. So again, I'm as staff to council and at the Oregon Department of Energy, I'm going to be providing an overview to the best that I can, delineate and separate aspects of the proposed order from the contested case issues. I'm going to be presenting material that's in the proposed order, which is a summary and reflection of how the preponderance of evidence indicates that the applicant has met applicable council standards with mitigation. But that's all derived from the application from site certificate. So as per usual, council is used to us telling you this. Once we get in front of you, everything's a series of boiling down a lot of information. The application for site certificate was over 22,000 pages. The proposed order without attachments, I think, is 600 or 700. With all the attachments, it's about 10,000 pages. Everything's voluminous. So again, it's very hard for us to like pick like the things we want you to focus on. And that's why we also highlight when we give you these materials and the staff reports and trying to hone in certain aspects to look in. So council has had the proposed order for 2 years. So I have selected things that I think are interesting. However, there's still a lot more in there. If council through your review has your own specific questions, please just interrupt, ask them. Also, if it's something that's appropriate for me to talk about, I can answer it. If it's kind of crossing over, Jesse can answer it. Sarah's here. We can go wherever the council wants to go, and I'm totally prepared to provide you the supporting documentation. If so we are ready. That said, and I've already burnt up 3 minutes. My portion should be about 7 minutes per standard. So I'm going to try to move along pretty fast. Some of my standards, I'm going to talk about kind of just the rule, the language of the rule, and that maybe is the best way to prepare you for what you're going to be going over with Jesse. Some of them are going to be going over the actual details and find under each standard. So we're going to start off with the structural standard. So the analysis area under council's definitions for the structural standard is the area within the site boundary. We talked about the site boundary earlier. Now, the applicant actually went beyond the area in the site boundary for particularly with seismic hazards, went out to 100 miles. It kind of corresponds with the magnitude, stronger magnitude. They went out further distances. So it went out for seismic earthquakes, went out to 100 miles. But then for all other like non-seismic hazards, the applicant actually went out and evaluated out to half a mile from the site boundary and a half a mile out. So then I'm gonna try to focus on the language of your standard, right? What is it asking? It's asking, did the applicant adequately characterize the site for seismic and non-seismic? And then can the applicant take that information and represent with mitigation or conditions that it can design, construct, and operate the facility in a manner that protects public health and safety in the environment? So, next slide, Nancy, please. Okay, I know it's kind of small in here. It's the actual data on these isn't, I'm not really asking council to zone in and see exactly what these are. These are pages that I've clipped out of attachment H1. Application exhibit H has information about structural, that supports the structural standard, which includes this very, again, voluminous preliminary geotechnical evaluation. They looked at soils, seismic data, looked at LIDO for landslides, and all of those were evaluated and presented in this map set and an evaluation done by by geotechnical engineers. So seismic is kind of pretty direct. We're looking at earthquakes. And then the other part of the council's structural standard is the non-seismic. So what is that? What are we looking at? So it's soils and issues associated with soils, which also has a kind of overlap with council's soil protection standard. But we also look at erosion, landslides, groundwater, expansive soils. These are other types of examples of non-seismic hazards that are evaluated so standard. So, on this, where the question is it's sub A and sub C of the standard. Has the applicant adequately characterized the site for seismic and non-seismic standards? So I'm going to go back. I'm not going to do this for everyone. For like under general standard of review, the question council's asking is the preponderance of evidence. Is it more likely than not that they have adequately characterized the site? So that's like that's the first step of the standard. Nancy, will you do the next slide, please? Okay, and then under the structural standard in the proposed order, it's a pretty lengthy condition. Council is used to seeing this condition in just kind of high-level summary. It's your pre-construction geotechnical evaluation and report that is conducted, that is site-specific, and that it's submitted prior to construction. Now, because this is a very linear facility, and so in some regards, because of that, it's going to be crossing a lot of lands, a lot of different types of, fault zones, areas that may be more or less impacted by landslides. The department, in preparation to understand this and to be able to, explain it to council, we've requested an investigation plan, which is basically the plan for the geotechnical plan. Help us look ahead to plan ahead for how we're going to evaluate and what type of geotechnical work is going to be provided. And then part of this condition is submit that geotechnical report, which is done based on evaluating, doing bore tests, soil tests, by certified engineers, of actually going out, doing that geotechnical work, submitting it to the department. And then the aspect that the facility must be designed, designed and cited based on the results of that. So the results actually matter. So that as to minimize and avoid or minimize risk to public health and safety in the environment. So now I'm going to highlight that sub 2 of the standard, or I'm sorry, it's B and D. The first one is, can the applicant or the standard ask the applicant to design, engineer, and construct the facility to avoid dangers to human safety in the environment presented by seismic hazards affecting the site? And then sub D is that non-seismic. So the question again, that's the question. You don't have to answer. You're not answering that one now, but just as an example of when we're going through of asking, council asking itself of what we're tasked with underneath this standard. And hold on, let me check my notes here. Too many of them. Okay. And that concludes my portion. So I'm going to pass it off to Jesse now. Actually, no, wait, no, I'm not. Okay, sorry. Council now gets to questions, any deliberations underneath the structural standard. It isn't related to a contested case issue. And I know it's going to be hard for you to navigate what is and isn't. So I feel like if you have questions about any of the materials that I covered, we can talk about it, answer questions, and then if it starts creeping over or there's overlap, then we can just send it over to Jesse, and we can end up doing also a straw poll at the very end, like after Jesse's, and do the structural standard, including the contested case issue and all that together.
So, Mr. Vice Chair, if I may, just from a procedural standpoint, kind of walk through, this is how we're going to, there's going to be some variation by issue and by standard, but with this one, there's, for this standard, there's one issue. And so what the structure is going to work is Kellen has done her presentation. Council certainly can ask questions. We can respond to anything you want. If you have no changes to the proposed order, not the proposed contested case order, but the proposed order, you do not need to do a straw poll at this point. But if you believe that you have, any changes to the proposed order, then that would be discussed and you can get that on the record and we would do a straw poll. But we're going to wait until after the oral testimony on the exceptions and the responses. You will then do a straw poll related to both the standard and the issue. So you would be making a straw poll. Say there's a couple of options. Say you agree with everything in the proposed order and everything in the proposed contested case order. The straw poll would essentially be to validate everything in the proposed order, everything in the contested case order related to the standard and that particular issue, meaning findings of fact, conclusions of law, and conditions of approval. So for the standard, when Kellen's portion, only if you have a change proposed to make would we do a straw poll. Otherwise, you would simply move on. Jesse would do the presentation on the issue, and then we would do in combination the proposed order and the proposed contested case order. So hopefully that makes sense and we can revisit if necessary. I think we'll get into the swing of things, but it's going probably to take a little bit to really grasp what we're doing here. So I can go over that again if you'd like, but just looking for your understanding or need for more explanation.
I think we've got a few questions. Counselor Jenkins.
Yeah, thank you, Mr. Chair. This is Hanley. So Kellen's going to present to us what is in the proposed order.
Correct.
Okay, and then we have an opportunity to question anything related to the proposed order. If
Not-
none,
Not in the contested case.
right, then we move to the contested case.
Correct.
When we move to the contested case, we look at the hearings officer's decision and the exceptions.
Correct.
Will we take testimony then on the exceptions?
Yes.
Ah,
And so we will wait until the conclusion of any oral testimony on the exceptions, any oral testimony as responses to the exceptions. The reason why we wanted to wait as a final is
right.
everything is so interrelated. We would like to be able to compartmentalize this out to say, clearly, this is only in the proposed order, and clearly, this is only in the proposed contested case order. It's a much more complicated than that.
Yeah.
And so rather than get to a straw poll on everything in the proposed order, not in the proposed contested case order, we wanted to give you the benefit of hearing from Kellen, and again, asking questions, and then again, if you have issues specifically you want to raise and make changes to the proposed order, this will be the time to do that for this standard. But say you don't, then again, maybe based upon the exception, the oral testimony, how you reviewed those exceptions, the responses, that may inform some other thought process where you then say, oh, well, maybe that wasn't in the contested case, but now I'm thinking about something in the proposed order that I would like to change. So we've tried to structure this it is complex. I certainly can't say that it's not complex. It is, but we're trying to make it as sort of rational as possible.
So what you're doing is you're providing us an opportunity to go back to the proposed order
Yes.
if need be as a result of the exceptions.
Yes, exactly. That's a better way to state it. Thank you.
Okay.
Counselor Byer.
We have this example right now, the proposed condition 1 for the structural standard. And that's what's in the proposed order. Based on what Hanley said, we'll hear testimony. We've read the exceptions. We could go back and change condition 1 to perhaps better address any of those exceptions if we felt it was necessary.
Yes, but that's already in the exceptions. So
Yeah.
the evaluation, of the issues in the contested cases and the exceptions that were filed already should relate to any conditions that are part of the proposed contested case order. It's more or less if by reviewing the exceptions and that issue in the contested case, does that inform something that's just in the proposed order that's not in the proposed contested case order? So it's more of an indirect connectivity versus a direct connectivity. So it may be that we work through this one. And again, I think it's
It'll
going to
help.
take one or two to kind of get through the swing of it, but we can revisit this, at any time to make sure and go over it again, so that you clearly grasp the way that we've structured these straw polls.
This is a time to ask questions of Kellen or comment on things that she said up to this point, but we
Correct.
don't want to do straw polls or anything. We wait first, then go to Mr. Ratcliffe's presentation of the exceptions in case we need to double back to the proposed order before we take
Correct.
straw polls
Unless,
on that.
for example, this condition, you say, well, we think this is only in the proposed order. This is unrelated to the contested case. And you say, we think this could be rewritten in a certain way. I'm just, again, throwing out an example. That's where you would deliberate and you would make a straw poll on that because it's only related to the proposed order. This is not related to the proposed contested case order. But again, you get a chance to revisit sort of theoretically everything in the structural standard when you do the straw poll vote at the end of the next stage, which is Jesse presenting the contested case issue, having oral comment, having oral comment responses to that. Then you would say, all right, is there anything in there that sort of reached back into the proposed order that I understand better now?
Councilor Jenkins?
Well, I struggled with this process, and I think I understand it now.
Yeah.
It is, I think, going to be difficult for us to make the connection between the contested case order and the proposed order. And so we'll have to be careful,
Yeah.
that we do that. And it may require separate polls in order to do that. So
Yeah.
we'll just have to be as aware as we possibly can.
Yeah.
And I think, like Todd says, I think we'll get in a
Go
rhythm.
through
here.
one.
Yeah. Yeah.
Well, and if I can offer, I feel like in between Jesse and us, like we are here. I know we're kind of compartmentalizing, but I think that if you just have questions, just have the conversation and we can help navigate. Well, we're going to push that over here and answer it over there, or maybe it's something that is appropriate for us and we can find the answer. So I think we can help you navigate that as well.
Okay. At this point, then, are there any questions, comments of Kellen on the structural standard for the proposed order? Councilor Condon, sorry.
Thank you. Just a question, maybe due to my lack of understanding of the standards, this standard just in general. So, Kellen, we determined that a site certificate should be granted. We are saying that it has been characterized, the site has been characterized correctly.
It's I'd say adequately characterized, right? So is it adequately characterized? And where's my we do have can you go back to the language of the standard, please, Nancy? Yeah, I'm just looking at it here. So it's through an appropriate site-specific study has adequately characterized the seismic, non-seismic risks. And then the B and D that they can design, engineer, and construct that facility, presumably based on that characterization, to avoid hazards to the environment and human health. And it's very typical that there is this now, so it's kind of like site-specific study, right? And so it's very typical for FSEC energy facilities that you do get this preliminary based on a lot of it is desktop analysis from Dogami, from various agencies. However, there is also field work that is done. The LIDO slide information is very site specific. And a lot of it will be the same information, and that information will show up in the final geotech engineering report, but it will also be based on field design, because that's also based on final design, because we kind of go back to that concept of the site boundary, micrositing corridor, and then kind of it's going to be trued up based on the final placement of the facility.
Thank you. I guess it's that desktop survey part of this that I have some discomfort with. This seems like a second bite at the apple that is certainly more on the ground. I want to make sure my understanding.
This is Sarah Esterson for the record. So I also wanted to highlight the council's information requirements that feed into the structural standard, which specifically state that a description and schedule of site-specific geotechnical work that will be performed before construction for inclusion in site certificate as conditions is an information requirement that has to be included in Exhibit H. And that's really where this condition that you see in every site certificate comes from, and then in some instances has much more detail given the amount of site-specific geotech work that might be needed.
And so just to finish this, so now there's further work done, which condition 1 requires. And so when we issue the site certificate, if we decide to issue a site certificate, this suggests to me that if we have now a new characterization on the ground, site certificate stands, and that we have confidence that the facility can be built, design, construction, consistent with the standard. It just seems to me 2 bits of information. We issue the site certificate with one set of information, and now we have new information that we have to be confident that they can design, build, meet the standard.
Yeah, I mean, that question applies across standards where, there's a large amount of true up based on actual data. So it is a combination of desktop and some survey combined with what you would get out of the condition. So it's asking of that second bite, is that second bite in the condition strong enough to meet the standard?
Okay, thank you.
So
This is Empire, and just for the record, any of these kind of after council decisions require the council to delegate the review to ODO staff, to Department of Energy staff. So the site-specific information on soils or landslide hazard would come back to you, and possibly with the assistance of Department of Geology to review to make sure the standard is still met within the approved projects. So I don't know what happens if within the site boundary there's a landslide hazard, if there's a design around that would happen as a result to still meet the standard. Is that the process, kind of?
Well, yes, on that the review is delegated to the department, and that we do engage our reviewing agencies, including Dogami. We also this would transition over to the siting analysts are involved, Sarah's involved, but it also goes to our compliance program, and we also work with consultants. We can have our consultants who assist with compliance, assist with that, who actually have geotechnical engineers. Now the last part of your question. So the question is if there's actually, so there's a seismic or non-seismic hazard, and then there's a design variation that happens to avoid that hazard. How would we know, or what is that? What is the question?
Empire, I'm not quite sure if I can follow completely through the process, but it sounds like the applicant would have the option to design around the hazard given the standard, that speaks to design and operation, I think.
The option or requirement?
So if in the site-specific geotech investigation that happens prior to construction, a landslide hazard is, and now we're getting a little close to SS5, to be honest, but a hazard is identified, that avoidance would be the first option, and then mitigation through geotech engineering, slope modification, drainage. There's different techniques that they would have to look at. And I just wanted to highlight a couple of the changes that we recommended council include in structural standard condition 1 as a result of issues raised at the DPO to try and strengthen it a little bit more. Was a requirement that the investigation plan, this is just the plan, that be prepared by a professional engineer or geologist licensed in Oregon. We wanted to make sure that they had experience with Oregon related issues. And then similarly, that report, that the result of that investigation be prepared by the same professional engineer geologist licensed in Oregon. And then we did add, I think based on facts that were presented in comments on the record of the DPO, additional specifics that had to be evaluated, different methodologies that had to be used to evaluate risks.
And Councilmember Byer, I think my numbering, I have it. No, it is 10. So in the condition sub 10, it's do the evaluation and then, additional information. It's one of the real lengthy conditions, but it says define and delineate geological and geotechnical hazards to the facility and identify means to mitigate the identified hazards. So there is a requirement that says, tell us if what you're seeing, and then how are you going to minimize or avoid them? Thank you for the questions.
Any other comments or questions from the council on the proposed order structural standard? So I think we're ready then, Mr. Ratcliffe, to move on to the exceptions on the structural standard.
All right, thank you, Mr. Vice Chair and members of the council. So the contested case issue that we're going to be going to, is issue SS5. The limited party is John White. The issue, and do we have a slide for the issue itself? I think we need to bring that up.
Yes. Keep going. Should be one more. Oh, the straw poll and the next one, Nancy.
Okay.
There you go.
Okay, so we have the issue up on the screen that was raised by Mr. White, whether the applicant has adequately evaluated construction-related blasting in Union County, the city of LeGrand, under the structural standard. Specifically, whether the applicant should be required to conduct site-specific geotech surveys to characterize risks from slope instability and radon emissions. And then on each one of these slides, since this is our first issue, we're going to be doing this. We're going to have the issue up on the screen, and we're going to have the references from the proposed contested case order, where the hearing officer made findings of fact on the issue, reached conclusions of law, and then wrote her opinion. And again, because of the complexity of this case, the number of issues, those are scattered throughout. And so, it sometimes will necessitate some page flipping to tie things together if we need to go to the proposed contested case order. But we wanted to get those references up on the screen. So, but what I'm going to do now before we call Mr. White up here to provide his argument is to go over the hearing officer's opinion briefly. And so what the hearing officer ruled on this particular issue is that the council's rules authorize the department to establish the level of analysis that must be included in an application. and allow consideration of the size and type of a proposed facility. So then the department's second amended project order, and the project order again kind of sets out the scope of the issues that will need to be covered in the application. That project order established that what's referred to as reconnaissance level, which involves some field level evaluation, and desktop, which is basically a review of existing literature pertaining to a subject matter, that this level of evaluation to provide a preliminary seismic and non-seismic risk identification at the site, that this kind of scope that the project order established for required investigations was adequate to evaluate compliance under the structural standard. The project order also established that a detailed site-specific geotech investigation for the entirety of the 300-mile site boundary was not required for the application due to limitations in practicality given to resulting from potential route and final design changes and limitations on site access. So that was one piece of the opinion, is that basically the level of information that the department was requiring that the applicant provide, that level of information was adequate to evaluate compliance under the standard. And so based on that project order, then the applicant has performed a significant amount of work to characterize the potential geological and soil hazards within the site boundary. And then the pre-construction condition, SS Condition 1, Structural Standard Condition 1, would evaluate and mitigate slope instability issues. The hearing officer's other conclusions were that Mr. White did not present facts or evidence to support his concerns that blasting would likely be needed during tower construction near his home. This is in LeGrand at tower numbers 108/3 to 109/2. And because site-specific studies have not yet been done, the standard had not been met. So that was, her looking at Mr. White's issue and concluding that there weren't facts or evidence to support that. And therefore, the hearing officer ruled that the council could find, based on compliance with the department's recommended structural standard conditions and soil protection condition 4, which includes a blasting plan, that the structural standard had been met with respect to that issue. So I'm going to stop for a second, and council's familiar with these materials. You've the exceptions. Nonetheless, what I just said was a mouthful and gets into some technical areas. I don't, I think the goal here is at this point to turn things over to Mr. White to provide his additional argument. But if there's just plain and simple confusion over anything that I just said with respect to the hearing officer's order, you can go ahead and ask questions related to that. And if there aren't any at this point, then I'm just going to provide a couple of guidelines for what the oral testimony needs to look like here.
At this point?
Okay.
Can look like it.
All right. So we're going to call Mr. White up here in a moment, and I just want to go over a couple of things about what the oral argument looks like here. And the main point I want to make is that the evidentiary record in this process is closed. And what that means is that if you have new documents, new information that you've learned that has not already been submitted into the record as part of the contested case process or as part of your DPO comments or however it came to be in the record, this is not the time to add new information, new factual information. And the by and large, the point of the contested case process is to make sure that there's ample opportunity to get that factual evidence into the record. What this is intended to do is to be an opportunity to address the council members through oral argument to talk about pieces of the exceptions that have been filed that address your issue, and to share those items with the council that you have particular concern about or want to highlight. So with that in mind, again, we're going to stay within the scope of the issue that you've been granted limited party status for. And if there's references to factual evidence, that it is to evidence that's already in the record of the contested case or the proposed order. So those are all the preliminaries I have. And so, Mr. White, whenever you're ready, you can come on up. Or do we have recorded? I guess that's the other thing I should say is we have recorded testimony from some folks who weren't able to make it here in person today. And so in some instances, we'll be listening to a recording and then seeing whether or not the applicant or the department have anything else to respond with.
Sure you're speaking.
Hello, council members. I'm petitioner Jonathan White, presenting issue SS5, which is about whether the applicant, Idaho Power, has adequately evaluated construction-related blasting near a populated area of LeGrand. I've been a homeowner in southeastern LeGrand for 12 years, and my home is located about 500 feet from the B2H site boundary at Hawthorne Street. My concerns have to do with damage to homes and local streets during construction. I'm asking that you reverse the ALJ's decision on issue SS5. The issue is about whether Idaho Power has complied with the relevant structural standard, which states that, quote, the applicant through appropriate site-specific study has adequately characterized the seismic hazard risk of the site. In other words, to obtain the council's approval for site certificate, Idaho Power must demonstrate that they've conducted site-specific geotechnical surveys to characterize risks from slope instability. In their response to my exception, Idaho Power acknowledges the wording of the relevant standard, but continues to claim that it's simply not practical to conduct, quote, a detailed site-specific geotechnical investigation for the entire site boundary in advance of obtaining full site access. My response to their response is, one, no one is requesting that Idaho Power investigate the entire site boundary. SS5 requests only that they investigate the stability of the slope above southeast LeGrand, an area identified as unconsolidated landslide debris in Idaho Power's application. Two, if Idaho Power has been able to comply because they haven't obtained full site access, that's their problem and not mine. Idaho Power's response is filled with lots of good intentions and excuses, but there's very little that shows actual compliance with the relevant standard. Note the repeated use of the future tense in the following quotations. Idaho Power will either avoid construction in areas of instability or will take robust measures to mitigate any impact. Idaho Power will conduct site-specific geologic and geotechnical investigations. Such investigations will be performed by a professional engineer or geologist. Where structures cannot be moved or realigned, Idaho Power will employ mitigation techniques. End of quotes. My reading of the structural standard is clear. Before the council can approve a site certificate to begin construction of the B2H, Idaho Power must comply with the Oregon administrative rules, which are designed to protect Oregonians from ill-considered projects such as this. And in addition, I just wanted to ask the council not to delegate part 2 of the review. Make Idaho Power come back to FSAC to prove they can meet the build part of the standard.
Mr. White?
Okay, so the next part of the process will be to see whether or not the applicant has a response, and followed by the department. And again, 3-minute time limit.
Good evening, council members. I'm Lisa Rackner, and I'm representing Idaho Power in this case. The core of Mr. White's exception is really the same subject matter that we've been grappling with already tonight, which is the phased study process, which allows the company to provide a desktop primarily desktop, but not completely desktop analysis in its application, in recognition of the fact that it's simply impractical for the company to do a detailed site-specific geotechnical analysis of the entire route before it has a site certificate, before it knows where the route is actually going to be, and based on the conditions in the site certificate can do all of the final siting and micro siting. It's at that point that it makes sense for the company to do this detailed geotechnical analysis. And the conditions that you've heard about are quite robust in terms of what will be required of the company. I hear Mr. White is concerned because a lot of these are commitments that are going to happen in the future, but they are commitments and they will be enforced by the council and they will be enforced by ODO. So once those geotechnical studies have been done, the studies will be done, first of all, in consultation with Dogami and with ODO staff, and all necessary mitigation, micrositing changes will be done to ensure that the transmission line is safely sited and will not present seismic risks. The other thing I wanted to point out is that this phase study process is consistent with the second amended project order, which asks the company to work with Dogami to put together an analysis that showed what we can do now, what needs to be done in the future. It's also consistent with your statutes, which allows you to issue a site certificate with conditions that then allow ODO to review the rest of the data as it comes in. So there will be robust geotechnical analysis. All of that analysis and working with ODO, any changes that need to be made will protect the public, and the condition has been satisfied. Thank you.
We have any response from department staff?
Just briefly, Patrick Rowe from the Department of Justice. I think this really comes down to council's level of comfort with the structural standard conditions. So I'd recommend it to the extent that you haven't already, take a hard look at them and make sure that you are comfortable with them. As the ALJ has noted, as has been noted in the briefs on this type of format, phased, doing studies after the site certificate is issued is common. It's common practice for council to approve site certificates with those types of conditions. So in this instance, you just need to look at the structural standard conditions 1 and 2, make sure you're comfortable with them. If there's anything that you think needs to be supplemented, then please let the department know, and the department, you would obviously need to let us know during the course of this hearing, and the department could make those changes in your final order. There is one note, it didn't come up in oral testimony, but it was in Mr. White's written brief on this exception, where he took issue with the proposed contested case order statement that there was, quote, significant work that has been done. And he took issue with the fact that there hasn't actually been significant field work that was done, but it was just desktop study that has been done. The department would recommend that that statement in the proposed contested case order be modified to clarify that the work that has been done to date has been reconnaissance level literature review and evaluation, just to remove any implication or suggestion that the work that Idaho Power has done to date has been significant field work. It's been significant literature review and evaluation. So you could clean that up in the proposed, you could modify that portion of the proposed contested case order.
Okay, so we have reached the stage now on this contested case issue where we're open for discussion among the council members. I'm here to act as a resource to answer any questions that I can about legal issues. Ms. Tardyweather and Ms. Esterson are available to be asked questions about locating information, which they're going to have a better ability to do than I will. If you want to see a page number of something, a piece of the proposed contested case order of an exception, whatever that might be, they can assist with that. But the goal from here is to, take a look at this particular issue that's been raised, see if there's a feeling that anything needs to be changed from the proposed contested case order. And then you're going to be circling back to the kind of the broader issue, with the goal of leaving the structural standard, because we just have the one exception filed on one structural standard issue, that we leave the structural standard with a good sense of where the council's at overall, not just the particular contested case issue, but the standard as a whole. So with that, I'll turn it over, and I'm available to answer questions.
Councilors, are there any comments or changes recommended for the proposed contested case order?
So do we have the page number for those conditions? Does somebody have them? I don't want to start thumbing around through here. Kellen?
In terms of the contested case, I would accept the recommendation of Council for Department of Energy to clarify that it was just significant desktop analysis. So that would be the only recommendation in the contested case, but I too would like to see the conditions so that we can ensure that those are responsive to the exception and to any other concerns.
I agree, and I think, do any of the council disagree with that, making sure that's included to clarify in the contested case order
this is Hanley. I agree with Ann, but I would like to see the conditions.
You want to see that? Yeah.
Just ask Wally to download the proposed order. So we at some point soon we'll be able to project on the screen the proposed conditions.
I've also put, oh wait.
So the page number of the proposed order is page 81 and 82. That has the language of structural standard condition 1. And structural standard condition 1 also references soil protection condition 4, which establishes a process where we have to get additional information prior to construction on any locations where blasting is identified as being necessary And then if that's the case, it routes you over to a blasting plan that's in soil protection condition 4. That condition has a formal state, local, and federal reviewing agency process prior to construction to ensure that the blasting plan is adequate.
Ms. Esserson, the standard was on page 81. The condition was on what page?
The condition is on pages 82 and 83. That's the
Thank you.
first condition.
So, Mr. Chair, this is a question for Jesse. At what point do we allow then a rebuttal? I guess it's rebuttal testimony. I mean, are we done with the testimony and now deliberating, or?
Yes, yes. So you've heard from Mr. White and from Idaho Power
Okay.
and the
That's
department
it?
on this, and
Okay.
that's it. And so,
Okay.
yeah, we're in
Thank you.
deliberation.
Okay, so up on the screen here, which is projected on through the webinar, is the proposed order in a PDF. So I can't go in and edit this, but this is, and so this is on, this condition starts on page 81 of the proposed order. It's kind of hard to see, but if for council, if they have their computer, now on your bottom left-hand screen, this is just one of those tips and tricks. There is this number thing. I'm circling my hand around it. So even though in the document it's page 81, if you type in 88 right there, it'll take you right to the page. This is it's like the PDF page number. But if we do any modifications, we will use the actual page number in the document, but this is just helping jumping around. Because we're in the big document with all the attachments. So I'm just going to slowly scroll down here. It's a little, and I know for folks in the back of the room, it's hard to see this, but.
Thank you, Mr. Chair. So Patrick, your recommendation doesn't go here. Your recommendation goes in the contested case order to be more clear about the information that's been provided to date.
I had made one recommendation with regard to just a cleanup of the proposed contested case order, and that related to Mr. White's written testimony where he took issue with the hearing officer stating that significant work had been done. And that's really a simple cleanup where council could clarify that significant reconnaissance desktop study work has been done, not significant field work.
Okay.
I also pointed out, though, that for the larger compliance with the structural standard, council should go through the exercise, which it's going through right now, which is reviewing the conditions the department has recommended and let the department know if there are any additions or revisions to those conditions council would want made in order to find compliance with this standard.
Councillor Byer, you brought up the issue of the significant work being clear that it was reconnaissance, not field. And we kind of dealt with that right when handling, or Councillor Jenkins was asking Ms. Tardiweather on where we find the condition in the document. And so let's circle back real quick and does the council agree with Counselor Byers' statement about clearing up the proposed order language. No, that was in the contested case language for the reconnaissance issue. Everybody in agreement with that?
Yeah, this is Hanley. I agree.
Cindy Condon, I agree.
This is Perry Chalk. I agree.
Okay, we've got that taken care of. Now we can circle back.
Now we go back to the proposed order
Correct.
and the conditions within the proposed order.
Right.
Yeah, see, this is going to be a little, we have to keep track of where we're at.
Yeah.
So,
And Mr. Vice Chair, I just want to jump in for a second here because we had a request from the court reporter to just remind everyone to speak up and to not speak too quickly so that she can make as good of a record as she can.
Mr. Vice Chair, for the record, Todd Cornett, just procedural element. So I do have language. Basically, I have potential language for all of these straw poll votes. So I've already reflected this. So even though you're kind of going through and saying, you know, does everybody agree? Does everybody agree? Which is great. I think for the record, for the formal record, it would be good to get the voice vote. And for me to read what I think it is that the council is interested in for both the standard and the issue. So I just want to put that in there before you get kind of too far and then we move to the next one. I think that would be good to have on the record because there will be consistency and clarity between each of the standards and each of the issues if we do it that way. But that's just my recommendation. You are certainly, you know.
yeah, this is Hanley. I think that's a good idea. That's probably going beyond a straw poll.
Yeah.
But
Yeah.
I think it's good because then we have an understanding of what it is that we're recommending.
Yeah.
And it's in writing.
Okay, let's have everybody verbally just walk through that.
Yeah, let's hear what Todd has.
Oh,
crap.
I would say though, you're still in that sort of discussion about the conditions related to the standard. If you want, if you're ready to have a straw poll and the contested case issue, certainly read that. Or still kind of reading or thinking about fact of law or conditions of or findings of fact, conclusions of law, conditions of order, contested case issue in the contested case. Should continue having that discussion before I get to that point of reading what I think you're where you're going.
Except I'm going to get confused.
yeah. You're not speaking, excuse me, Secretary Cornett, you're not speaking to the action or not action, but the position we just took on the proposed contested case order, clarifying the language on the reconnaissance work.
Well, so the way we've structured, and we can do that singly by itself if you want to.
Yeah.
We currently have it structured as a combined standard and issue. I can separate that if you want.
Yeah, I'd like it separated. This is Hanley.
Okay.
Yeah. Okay.
So
I think we have a straw poll on
that,
that unless the language doesn't get us there.
But I think so yes, I can separate that out, but I think we still, we didn't get a sort of verbal, we the council agree with the proposed order for the structural standard yet.
Yeah, well,
We still need to get there.
I think we'll go back to
Okay.
that.
So if you want, I can read again where I
Yeah.
think you're going just with the issue.
Yes.
Okay. So, and again, this is not like in the form of a more formal motion. This is just to clarify my understanding. So, council, you agree with the findings of fact, conclusions of law, and conditions of approval. Oh, in this case, the findings of fact, conclusions of law in the proposed contested case order pertaining to issue S5 with the following modification to change the language to reflect in that the significant reconnaissance desktop work has been done. And essentially what this does is it gives us on the record so we can go back and make a change in the draft final order to reflect all of these changes. So it doesn't have to be perfect language. It just has to be enough to give us that understanding of where you were going tonight so we can reflect that in the draft of the final order.
Right.
Okay, let's each council member go through and Did you
I
have
can,
more
I can just roll
discussion?
call if you
Oh, you
want.
can do a roll call?
Yeah.
Do that.
For Condon here. I'm not sure I agree with, I agree that I want to clarify the language from significant. Not sure I'm ready to accept the contested case, which I think I heard in your statement. That we were accepting the findings of fact and the conclusions of law.
Oh, I see what you're
And so
saying.
I'm not quite there yet.
So that's where I think, again, this vote, there should be, I mean, we can split these out, but it gets much more complicated. So it would be better if you're deliberating and there are multiple things that you get to that conclusion of this is what we think, and you do it in one straw poll. And if there are multiple modifications, those can be reflected in that one straw poll, but not do, there's already going to be about 70 of these things. And so, you know, if we split them out, we're doubling those. So it would be easier if when you're ready, you know, even if you want to split out the proposed order versus the proposed contested case order, but you do it one time. And in this case, you have one change. I think that's reflected. If you have other thoughts or ideas, you should have that conversation and deliberation first. Then we get to the straw poll on that, inclusive of, you know, any of the changes that you want made.
Councilmember Condon again. I would like to wait. I do have some other questions on the contested case, and I am wondering if we have the opportunity to ask Mr. White and Idaho Power questions on their testimony. I thought we were going to have that.
Vice Chair Howe, Councilmember Condon, that is at the council's discretion. You know, I think the idea with the oral argument is to provide everyone an opportunity to, you know, to list the important issues and then provide responses. But if there are specific questions, that is okay if that's what you want to do. The one place that I will try to kind of keep things consistent is to make sure that we're not veering into something that is not already included in the evidentiary record, because that is important that we, you know, acknowledge that that's been closed, and that we need to stick to that.
Councilor Condon.
Councilmember Condon here. I am just a bit confused by the contested case on page 268. And this is the first time I've read through a contested case. So in Mr. White's testimony, he's concerned about stability on a hill, and I heard no mention of water. On page 268, discussing structural standard 5, there's an addition, I think, on B. I don't know if we want to call it prior to construction, the certificate holder will consult with landowners regarding right-of-way acquisition. It's rather long, but it speaks to water. And I'm just questioning, is this a water? Is Mr. White concerned about water or stability of the hill? And secondly, for Idaho Power, Mr. White said pretty clearly, and I don't see it anywhere, that anybody's asking for a full structural stability study on the ground for the whole project, but just this one piece, the hills over the Grand. And I'd just like you to clarify for me, talking about the whole project versus this piece of it, to satisfy maybe some of the concerns prior to site certificate being issued. So yeah, or I don't know what order that or how we want to do
Can you
this.
give some clarification, Jesse, on how to proceed?
Yeah, and again, this is going to be at the council's discretion how you want to handle this. I think that, you know, the to keep things as fair and as clear as possible, you know, if a council member has a question, we should, you know, you should direct that to whoever it is that you want to hear from, provide the other party an opportunity to say something about it as well. And, you know, in this particular instance, I heard you ask a question that sounded like it was directed to Mr. White. And so, you know, I think, again, to be fair, it would make sense to have him answer that and then to see if Idaho Power has anything else that they want to say about that. And again, I don't want to sound like a broken record on this, but we really, really need to keep things confined to what is on the record. I don't think we've strayed from that at all, but it's just something I want everybody to keep in mind.
Okay, it sounds then like we're giving the opportunity to Mr. White to come up and answer the question that Councilor Condon has asked, with no new information being presented.
Okay, the question I think I heard was this about water on the slope? And it's really about, in the application, there are maps and descriptions of the area around La Grande, and the area is described as unstable in the form of unconsolidated landslide debris. And everyone who lives in the area knows what that's about. You know, the driveways are cracking and basically pulling apart. It's a very unstable area, so people are concerned about that. And also the blasting plan mentioned earlier never specifies where blasting is going to occur. So we just don't know. They might decide to blast, they might not. Is there anything else?
Thank you. Just to confirm, it was not specific to water. It's stability for the hill. And
Yes.
there's no request that I have heard or read about of you or anyone else saying there needs to be an analysis of the whole
Correct. Yeah, no one
transmission
that I've
line
heard
path.
has been saying that.
Yeah.
Right.
Thank you.
Okay.
Okay, does Idaho Power wish to?
Just very briefly, I've been able to confirm, and this is in the record, that the geotech plan there is a plan to specifically address and do detailed geotechnical studies of the area that Mr. White is concerned about. That is something that will be done once we know where the route is going to do. Those types of studies are not particularly effective until you know you have the final design and routing. And one other point I would ask the council to consider is that it certainly isn't in Idaho Power's interest to place a tower in an unstable area. Not only are we required by law to avoid those types of risks, but it would be something that Idaho Power, regardless of the law, would avoid. And we hope that that gives the council some comfort about our intentions of doing very serious geotechnical work, particularly in areas of concern prior to any construction.
Thank you. Okay, so council, are there any suggestions or recommended changes to the conditions under this structural standard number 5? In the proposed order? No, is this in the?
That's the case order.
This is in the contested case order, sorry. That's right. Yeah. Jesse. Ratcliffe.
Councilmember Condon again. Mr. Ratcliffe, on page 268, bolded paragraph.
Maybe faster for you to show him that.
Sorry, is that a condition, a required condition in the contested case order? It's
On page 268
268.
is contested case issue SS3, for which there
SS
were no exceptions filed, which was more specific to blasting and potential impacts to water quality. No, we're talking about SS5.
No, I think
Oh,
that was related to Mr. White's.
Yeah,
different,
so-
different party.
We have an amended recommended soil condition number 4, and that includes the highlighted information that you're pointing to. And so that is a recommendation from the hearing officer to include that language. So as the proposed contested case order is written, if adopted, that would include this bolded language.
But not related to structural standard 5. Misread that then.
It's not, it wasn't, this language didn't arise from structural standard issue 5, but it is a piece of the proposed contested case order. And so should you adopt the proposed contested case order without modifying this piece, then that bolded language will go in. So since we're in this kind of narrowing down of issues, we have a number of issues on which no exceptions were filed, where the hearing officer may have made changes from the agency's proposed order to address some of the concerns that were raised by the person who requested that contested case issue. And, I don't have the specifics of this, or know the reason why this person didn't file an exception. But it's entirely possible that, that revision met the concerns of the person involved. So
My error, I think.
Okay, then back to structural standard 5. There's a lot of interweaving going on here between different structural standards, but sounds like that one was taken care of under structural standard 3. Let's go back to structural standard 5. Are there any further comments or recommendations for changes to conditions under the proposed contested case order related to structural standard 5? Seems hearing none. Maybe we got through that one. And now we need to go back to the proposed order.
No,
And-
we did not. There was no straw poll.
Right.
So we stopped the straw poll and then you went into deliberation. So we need to go back to the straw poll on the proposed contested case order
Okay.
before we go back to the proposed order.
So in doing the straw poll, do we want you to poll us?
Yes.
Okay.
So unless there's any other changes, I can read that one.
We'll include the language that, yes, okay, that Patrick suggested. Okay.
Okay. So as I have it articulated, council will agree with the findings of fact, conclusions of law, and conditions of approval in the proposed contested case order pertaining to issue S5 with the following modifications to make the changes to reflect that the proposed contested case order, that's duplication, that significant reconnaissance desktop survey was conducted. Okay, so Hanley Jenkins, Perry Chalktooth,
Yes.
Ken Howe,
Yes.
Ann Byer, Jordan Truitt,
Yes.
Cindy Condon.
Yes.
Thank you. And then now back to the proposed order. Correct.
Yes. Counselor Byer?
Just conferred with our council. I had a question on the blasting component of this condition, which requires notice, but notice through a newspaper. And newspapers aren't always the best source of information these days. And I'm wondering if it is impractical to ask that the applicant notify property owners within a given distance of a blasting activity. I know that's something we regularly did at the local level, just to make sure that property owners were aware that something was going to happen. I think the other conditions are appropriate in terms of notice, but I think the newspaper notice alone is probably not the best vehicle. So thank you.
How's the council feel about that suggestion on notice?
So thank you for the question, Councilmember Jenkins. I'm trying to remember what we did at the local level, and I don't know if it's 500 feet from the impact area or a half mile. I am the wrong person to ask about distance, but thinking about the impact of blasting and just letting people know that it's going to happen. I just can't remember from our local code what we required, but somebody with practical experience could help inform this. Thank you.
This is Patrick Rowe, the Department of Justice. Can I just seek clarification on, are you referencing, Councilor Byer, to the amended recommended soil protection condition 4 in the proposed contested case order?
Described in section protection structure blasting makes necessary, and then some conditions on page 8.
Okay, I see it now. Thank you.
Councilmember Byer, I know the intent is to give very clear and objective standards, so I think notice within, notice to property owners of record within a certain distance would be appropriate.
Since we don't know what that distance is right now, is that something staff can come back to us with tomorrow when we come back to this? I hate doing that, but.
For the applicant's construction contractor to do a mailed notice to property owners within blasting of some unknown distance.
Give more direction within a certain time frame, at least a week in advance or something. And I can look at our county code language tonight to see if I can find something specific. I don't mean to be so onerous, but when you give notice, it's good to get the notice to the people who are affected.
So first of all, I think we need to find out, where's the council on this?
Well, let me ask Ann, this is Hanley. So this would be in addition to the 1 week notice in the newspaper or in replacement of?
I don't feel strongly either way, but I think it's critical to target the notice. I hate to say this in public, but not many people read public notices in newspapers.
I'm just going to offer, because this would be the applicant or its construction contractor, and I guess And we're just so programmed that when you say notice, I get a procedural trigger in my head and it means a certain thing. So I don't, and maybe Jesse could offer, if you end up going down that route, we call it a, information up, I just don't know. Some people are used to having a notice be anyhow. So just mindful of the language so we don't venture into creating a process step that.
Thank you. That's a good clarification.
So this is handling, and there's, if you read on in this condition, it talks about giving written notice at the points of entry. Warning signs would include information on blasting, including the general hours of blasting might take place. Access points to areas where blasting would take place would be blocked. I know what you're asking, and I think that's very considerate of the landowners that are going to receive the greatest amount of impact. They may want to stand there and hold their dishes or something, but I guess I'm worried about adding to the condition. This is, I guess, is a question for Jesse. Does this open us up for additional testimony, on the condition?
So the standard for changes to the proposed order is whether there's a material change. And if that's the case, then you have a hearing that's specific to the material change. Now, the question is, what is a material change? Generally speaking, a change to the outcome, obviously do they meet the standard or do they not meet the standard? Well, that's clearly material. Conditions, I would recommend that you view changes to conditions as material. Those are, at the end of the day, the things that the applicant must do. Now, this is, in some ways a kind of minor technical change. It may really matter to people on the ground. So I'm not saying it's minor from that perspective, but in terms of what we're asking of the applicant to do, it's not some kind of categorical, this is really different. It's notice. It's still notice. How do you do the notice? But to be conservative, I would suggest that if you're looking at changes to conditions, that you give an opportunity, that you consider that material and have an opportunity for comment on that.
For the record, Todd Cornett, if I may, just procedurally, the way we have this structured would be, if we conclude all of the exceptions in these 3 days, then we have council's direction. That's what we're seeking here through all these straw polls, is council's direction on the proposed order and any changes, as well as the proposed contested case order and any changes. We would then, in the coming weeks, issue a draft of a final order. It's not a final order, it's a draft of a final order to reflect what we hear from council. And we would identify any material changes. So this would be an example, as Jesse said, a material change. We would identify this as a material change. And then at the next council meeting where you're reviewing, it's a two-stage sort of process where you would then conduct a material change hearing and allow people to provide comment on those material changes. So this could be one of them. And then if you're ready, then you would potentially be ready to issue a final order, and make a final decision on the project. So just kind of, again, procedurally, anytime you're going through the, proposed order, proposed contested case order, and you're making material changes, as Jesse mentioned, those would constitute an ability to make a
So not now.
Just want to thank you all for your patience with me because this is the first time I've been through this, and knowing that the material changes triggers another hearing is important. So, and without being able to offer a very specific recommendation, we can move on, but thank you.
Okay, we've been at this for almost 3 hours, maybe break time, but do we want to finish this one item and then take a break for grabbing supper? So where's the council on this issue? Notice and giving direction to staff in changing the proposed order.
Yeah, I guess I agree with Ann. You know, it's appropriate, I think, to give people within a half mile of a blasting site notice in advance. In the news, then the condition right now requires 1 week in the newspaper. I think simultaneous with the 1 week in the newspaper, you give notice to the adjacent landowners within a half mile.
Councilor Condon?
It's Councilmember Condon. I agree with that. And I'm wondering also in the posting of signs, there's no indication about when they're posted. Like, are they posted on the day that blasting occurs? I think it would be helpful to have some time period, like the week before, you know, as long as we're making changes. It just seems to me that people in the areas should have as much notice as, or not as possible, but prior notice. Thank you.
Well, and since they know, I mean, they got to give the notice in the newspaper and adjacent landowners within a week. They should be able to put the signs up within a week also.
Jordan Truitt for the record. I'm no blasting expert, and no doubt there is a statute rules. It's probably as big as this binder for blasting, and I'm a little hesitant to speculate as to what the appropriate notice or radius might be without knowing those rules. And so I agree with what you're saying, proper notice, but I fall back to proper notification within the rules and requirements for blasting activity in urban type settings or within proximity to population centers. So without knowing what they are, I do think it's a valid concern.
And staff can come back with that. Councilor Choptuk?
Yeah, Perry Chalktooth for the record. Depending on the geotechnical investigation, blasting could be pretty hazardous, so early warning is going to be the better. So I agree.
Okay. Does staff have what you need for this?
So can you let me know what the condition number is again?
Should be soil protection condition 4.
No, it's actually at the end of structural standard condition 1.
I don't think that's where we should put it.
That's where the language is now that Councilor Beyer has pointed out that she would like to have supplemented. So if you look at the proposed order, pages 82 to 83, that's the language she's referencing.
That's not condition language.
So what
Go to page 82 to 83 of the proposed contested case order.
this is not what she from the blasting plan protection condition.
It's sorry to have opened up a can of worms.
So what I have on my screen here, oh, well, I write it down. So under the structural standard, we include a provision, and I'm just walking you through so we can kind of just all get oriented here. We added in the proposed order this reference to kind of the submission process to include and contemplate. It's kind of connecting structural with the soil protection standard, because the blasting plan is imposed underneath the soil protection standard. And so this component of the structural standard is kind of connecting the two. And so what we often do is under one standard, we also say, like, these are interconnected. And so this bulleting here that you see on proposed order page 83, I believe, is staff's summary of the information in the draft blasting plan that is imposed under recommended soil protection condition 4. Okay, so, and soil, and I'm just going to summarize, soil protection condition 4, like some conditions, some are very detailed. Some of them say, hey, do that plan. Finalize that plan, do that plan. So really where we should be going is to the plan, rather than modifying any condition. However, as Jesse was talking about, because functionally the condition says do the plan, if you change the plan, this would still be considered a material change. So I'm gonna try to pull up the blasting plan.
The best level of detail is there that you're looking at. Go to the notice, go down.
So
Last
maybe is this the time? Have we finished structural standard 5? Or both the,
Yeah, so we already conducted the straw poll on structural standard issue 5. And so now we're just into the proposed order. So you're going back into what the proposed order findings and conditions are.
So we would basically
Specific language for the proposed order?
Well, we're going to need something. And so, I mean, so right now we have a proposed order.
Right.
That proposed order is essentially what's on the books. Only those issues that are in the contested case were challenged. And so you're going back to the proposed order to make changes. And so we need some clarification as to what you want to do and why in order to justify specific language. So you can certainly give us clarity and guidance, but enough specificity so we can actually do that. So say, I'm not picking on you. We want to do notice. That's not good enough. Frankly, it's not good enough. You need to be very clear as to when, how frequent, in what form, how wide out, what sort of, so the details can be filled out, because we can't just sort of generate a concept of a notice out of thin air based on what you're saying. This is not a notice that's in our rules related to property owner notification. If it was a property owner notification for a draft proposed order, we have that framework set. We're all good there. You're creating something completely different. This was not evaluated during the draft proposed order. There was no comments on this. So you're creating this out of thin air today. So we need the details and the specificity from you in order to be able to reflect this in a draft of a final order.
Chair Howell.
Councilor Condon?
Councilmember Condon. So, Todd, I don't see how we're creating this from thin air. So we have it in the proposed order that newspaper 1 week prior. If we say now there's mail notices 1 week prior.
But to whom, how, in
Right.
what form, who's going to be giving those? Is it the department's responsibility? Is it the applicant's responsibility? What's the nature? There has to be some specific form to describe, again, where we have very clear rules about notification. It says when we have to do it, how we have to do it, clearly what has to be in the notice itself to meet the requirements. So just saying notice, that's not guidance to us or a construction contractor. So if you're saying the same information that's in the notice in the newspaper needs to be put in a property owner notification, and that needs to go out at a minimum of 1 week prior to all the people on the most recent property owner tax rolls on the county assessor records, that's something where we can work with. But just simply saying notice, again, we don't know what that means. You have to be specific as to, what we're talking about here. And so it's not creating it out of thin air. So that was probably not the right characterization, but the property owner notification does not exist right now. And so what your purpose and intent of that is needs to be clear to us.
So Chair Howe, I think as Kellen and Sarah mentioned, there's more detail in the requirements for a blasting plan. And if you can direct us to that and see if these issues are already addressed in that very specific plan requirement, we won't need to modify this. If not, I agree with Secretary Cornett that we do need to be very specific in what we're asking the applicant or the applicant's contractor to do. And I think there are good examples out there. There's a reference to the blasting code that probably has very specific requirements. So I think perhaps tabling this for now so we can do some homework, knowing that it's something we may want to add some language on, but being prepared to come back with something more specific so we can move on to other issues.
So again, procedurally, we did put a placeholder at the very end on Wednesday. So if there are any unresolved issues like this, if you think you want to do it, but you're not sure of the specifics, we do have some time to work that out before the conclusion on Wednesday.
Thank you, and thank you for your patience, fellow council members. But
Where's the council on this? Ready to punt to Wednesday on this issue, or? Keep working on it?
Yeah, so this is Hanley, and do we know the specific requirements for the blasting plan?
The draft framework blasting plan, and we have a table of contents and general information under each of the table of content components. So it still has to be finalized. We have referenced some of the NFPA requirements that were cited to us by Dogami as what might apply for monitoring seismic shaking during blasting. This isn't a plan designed to demonstrate compliance with all blasting requirements. So it doesn't currently detail any of that, but those that we thought folded into the structural standard based on our consultation with Dogami are referenced.
Yeah, I wanted to finish Structural Standard 5 before we took a break, come back and pick up Financial Assurance Standard 1. We're still on it.
We're still on the structural standard.
Yeah.
We are done with structural standard 5, or the contested case issue 5, or the structural standard issue 5. So just for clarification, everything else in the structural standard is okay.
Yeah.
So you're good with that in the proposed order. It's just the question of the blasting notification. Okay. So at least, again, I think with that, we have time to, either you do or we do have the ability to think through that a little bit and have some kind of, straw proposal for Wednesday.
Okay.
As long as that's the only issue. But I'd say if there are other unresolved issues, we should continue working through those.
No, I think that's, as far as this is handling, as far as I'm concerned, that's the only unresolved issue. And I do agree with Ann's interest in notifying the adjacent landowners or nearby landowners. And I understand the department's position that we need to be specific about how we do that or how we recommend we do that. It's not, if it's the same thing as the newspaper notice, then is it to the occupants or is it to the landowners? And, and so forth and so on. I think we need to be clear about that. So I think it's a Wednesday issue.
Okay. So then I would recommend at this point taking a break. Dinner is here. So however long council wants to take a break, it's designed as a working lunch. We're already about an hour behind on the schedule for tonight for the two or the three issues that we want to get through, or the three standards that we want to get through. So I, again, should take as much break as we need to, but shouldn't linger too long since it's already 7:05.
Okay. So I'm
And
looking
I
at
know
the
that
council. How long do you want? Just get it and come back? Okay, take a 15-minute. It's 7:05, so at 7:20, we'll be running again.
Oh, no, this is what this is.
And financial assurance, standard and issue RFA 1. So Ms. Tardy-Weather, you're on.
Thank you, Vice Chair Howe. I'm looking over at just waiting for our PowerPoint to get queued up. For the record, Kellen Tardy-Weather, Oregon Department of Energy. So while we're getting the PowerPoint queued up in its PDF format, just kind of talk about we've talked quite a bit about the retirement and financial assurance standard for other projects. I feel like council is pretty familiar with the standard, but I think that this is a good opportunity to remind council about the interconnectedness in between our standards. And part of under retirement, we do look to findings of fact and conclusions of law under the organizational expertise standard. And in July, we did review the organizational expertise standard. And council didn't have any revisions underneath that standard. So just kind of reminding council there that we kind of looked at that, but organizational expertise also has an aspect that relies on retirement. So we're just kind of keeping these in mind. You guys working on the PowerPoint? Okay. Well, I'm just we're 1 minute. Oh, it's okay, good. Yeah, the one right above that. So yeah, but just the language, standard language. Yes, correct. And Crystal, the court reporter, are you still with us?
Yes.
Okay, great. And we'll all try to speak loudly and enunciate and also talk slow, but also fast. Sorry. The council's retirement and financial assurance has two aspects. One, that can the applicant taking into account mitigation, can they ensure that the site would be restored to a useful non-hazardous condition? And then the second aspect is that there's reasonable likelihood that that the applicant can obtain a bond or a letter of credit in a form and an amount satisfactory to the council to restore the site to that useful non-hazardous condition. So, the applicant represents that the useful life of the facility is approximately 100 years. This is longer than council sees for some other facilities. This is also something that is asked to be presented in the application that we then, rely in our findings. So the applicant says that the transmission line would, the approximate lifespan is about 100 years, but really it expects that it's going to remain in operation functionally in perpetuity. The applicant and its parent company, IDACORP, they've been in operation, or the company originated in 1915. So we talked about this under the organizational expertise. This is a regulated utility in Oregon and Idaho. They have constructed and operated several transmission lines that have been in operation for long periods of time. and that over time, the transmission lines get upgraded and maintained to that, to where they do have, and can safely operate within these, longer durations and time spans, because that is the transmission structure of our energy system. So let me see. Oh, the next slide, Wally or Nancy. Now, so, oops, nope, the one with the table on it. So maybe the previous one. Sorry. Okay, we've gone. I have the table that council's used to seeing, where we break out and we talk about the tasks of how would this facility be retired, and the assumption is that it's full build out. Can you go to the slide with the table on it? I think it's the one right before this. Yes, and that's impossible to see. So you're welcome. I can find the page on your proposed order, though. Do you think you could? Okay. So this task, oh, that's kind of helpful. It breaks out all the line items on our retirement. When we do the cost estimating to get the estimated bond amount to retire the entire facility, it is at full build out. So we're maximum footprint, maximum everything. It's on your proposed order, page 296. This table is. So, the discussion of the activities to restore the site are kind of reverse construction. So we're taking down the poles, taking down the cabling, removing an EFU land, the foundations for the transmission structures, and all of those get reviewed and a price tag put next to them. One of the major components for the facility are the related supporting facilities, which are the roads, or one of them is the roads. Roads would be, decompacted, reseeded. If new soil would needed to be brought in, that would happen. The road restoration would be a pretty significant component to retiring the facility. So, thank you. Sorry for my pause here, folks. Okay, so now, next slide, please, Nancy. So council looked at this standard in its review of the draft proposed order, and actually had a pretty robust discussion underneath this standard. In the proposed order, your recommended financial assurance condition 5, which is the bond that applies during operation, is related to a contested case issue. So I'm going to leave that for Jesse to talk about, but just kind of reminding council, because council was kind of a different council, then that we did actually, some of those revisions that you see in the proposed order for condition 5 came out of council's deliberation and discussion and direction to staff at its review of the draft proposed order. So I'm going to talk just briefly about financial assurance condition 4. So this is a condition that the applicant proposes to apply during construction. And it says, because we're kind of going back to the general standard of review condition that said, we're going to give them 4 years to begin construction. And once they start, they can have 4 years to complete construction. So we're kind of looking at 4 years to build this facility. And what this condition says, and I am paraphrasing because this is a pretty long condition, but it basically increases the bonding amount to reach, which I'm sorry, at that table, that the total is up about $140 million that we're saying would be appropriate to retire and restore the site, retire the facility, restore the site. So this condition 4 says that during construction, every quarter, the amount would increase, getting to that 140, which would then also be adjusted based on, the inflation factors, et cetera. Each quarter getting up to that $140 million. And this is to cover, to contemplate that as time goes forward, there's more facility on the ground that would then, if needed to be retired, it would, yes, the bond amount would be commensurate with the amount of facility that would be on the ground throughout the construction period. And I think that I'm just going to stop there. Did you have anything you wanted to add? Yeah, I'm going to stop there and I will, well, I'll pass it off to Jesse, but we can just kind of take a pause. Does council have any questions about how we generated that 140, the table?
Questions from council? Looks like not.
Okay, great. I'm going to pass it off to Jesse. And then, so will you guys go to the next slide, Nancy? Nope. Okay, so next one. Yeah. Yes. Right there.
Okay, thank you, Kellen. So we have one contested case issue that drew exceptions for the retirement and financial assurance standard, RFA 1. The party is Irene Gilbert. The issue that was raised in the contested case is whether the $1 bond amount adequately protects the public from facility abandonment and provides a basis for the estimated useful life of the facility. So the hearing officer's findings of fact and opinion on this are that the council rules give discretion to the council to allow an amount less than the full cost of site restoration. That the rule allows for the certificate holder to have a bond or letter of credit in a form and amount satisfactory to the council. The site certificate condition, one of the mandatory site certificate conditions, and again, a lot of the conditions that we're talking about here in these contested case issues are conditions that were added, either they were proposed by Idaho Power or they were requested by the council or they were proposed by staff to ensure that the standards are met. But there are a set of mandatory conditions in the council's reviews. One of these conditions allows for the bond or letter of credit amount to differ during construction and operation. The hearing officer went on to find that the dollar bond was proposed by Idaho Power once the facility is operational because of the low risk as a PUC regulated facility. And it's a significant cost, roughly $880,000 a year, to maintain the bond would be passed on to ratepayers. The hearing officer also looked at Idaho Power's credit rating, concluding that it had access to secured and unsecured credit at reasonable rates and under acceptable terms. For example, pointing to a $300 million credit facility with a syndicate of large financial institutions. In contrast, the hearing officer looked at the evidence provided by the limited party and concluded that there was insufficient evidence to support the claim that the dollar bond for the first 50 years of operation is insufficient, or that the facility is likely to become obsolete, or that Idaho Power will become insolvent. And then the final conclusion here is related to an argument that was made by Ms. Gilbert comparing solar facilities to the transmission line, and the hearing officer's conclusion was that the two were dissimilar enough that they didn't serve as a useful comparison to a PUC regulated major transmission line. So that is an overview of how the hearing officer dealt with that and how it was written up in the proposed contested case order. So I'd like to go ahead and have, with Vice Chair Howe's leave, to call Ms. Gilbert to provide her 3 minutes of oral argument. And again, the reminder that the oral argument and any responses should be limited to information that is already in the evidentiary record.
Am I on? Am I easy to understand? Okay. Irene Gilbert here, and I've requested an exception to the proposed contested case order failing to require the developer to maintain a bond in the amount established by council to restore the facility site to a useful non-hazardous condition. In the alternative, I have identified 3 site certificate conditions which I'm requesting be implemented to provide protection to the public and the state from facility abandonment or default from any unplanned event. The necessity of requiring a bond is supported by the fact that it is identified as a mandatory site certificate condition, and council rules specifically deny the council the authority to use a balancing determination in the valuation of this rule. I identified multiple issues of fact in the form of statutes, rules, court decisions, and examples of bankrupt companies which are being waived or reinterpreted in the event council approves a $1 bond or reduced bond amount and places the state and taxpayers in jeopardy. The proposed contested case order fails to identify the required facts and conclusions of law regarding each of the arguments supporting a denial of this contested case. Multiple court decisions limit council authority to waive or interpret rules or statutes to rules that are genuinely ambiguous, including Gonzalez versus Oregon and the U.S. Supreme Court decision in Kaiser versus Wilkie, which also requires the interpretations to be reasonable and that there cannot be a new interpretation that creates unfair surprise to regulated parties. While the department and Idaho Power will argue that FSAC is not bound by U.S. Supreme Court decisions, the council should carefully consider whether it is prudent to accept such an argument. The council does not have unlimited power to interpret and reinterpret rules and statutes of the agency. The Oregon Supreme Court in a recent ruling stated that the council acted, quote, without a reasonable basis in fact or law. You are being asked to apply the actual unambiguous language of the council rules regarding the required bond amount and do so in a manner that is consistent with the council decisions before and after B2H, including requiring the bond amount to be the amount the council identified as necessary to restore the site, which has always been interpreted as the amount satisfactory to the council for the bond. Your decision needs to be consistent with the recommendations from your consultant, Golder and Associates, and the amounts being required of other developers, also the training that you receive from Odo's staff. The risk of requiring the use of a bond is always going to be minimal. As with any insurance, it is to protect from the unlikely but possible events. The file fails to document that there is a preponderance of evidence that the rules and statutes requiring a bond are being met. I urge council to reject the denial of this contested case and site certificate and conditions as the current bond amount fails to meet the requirements that the interpretation be reasonable and not create unfair surprise. Thank you.
Ms. Gilbert, are there any questions from council of Ms. Gilbert? Okay, thank you.
Good evening again, Lisa Brackner for Idaho Power. In her exceptions, Ms. Gilbert argues that the council's rules prohibit it from taking a flexible approach to its bonding requirements to recognize specific risks presented by each project. But as a matter of law, the council does have that flexibility. And as a matter of policy, the council should exercise that flexibility in this case. First, as a matter of law, the council's rules quite clearly allow the council to exercise its discretion as to the appropriate amount of a bond. The rules state that in order to issue a site certificate, the council must find that the applicant has a reasonable likelihood of obtaining a bond or letter of credit in a form or amount satisfactory to the council. That language, satisfactory to the council, plainly indicates that the council is to exercise its judgment as to the appropriate amount of the bond. It's also consistent with mandatory condition 8, which repeats that the bond must be in a form and amount satisfactory to the council. Ms. Gilbert's interpretation would require the council to completely ignore the critical language in the rules, which is inconsistent with basic rules of statutory construction. Moreover, as a matter of policy, B2H's application confirms that a phased-in bonding approach is reasonable. And I want to quickly say, the bond doesn't stay at $1 for the entire life. The bond is designed to increase up to the full decommissioning amount by 100 years. So it starts at year 50, increasing on a regular basis. The cost to maintain a bond is high and as Mr. Ratcliffe said, would be borne by ratepayers. Moreover, the risk that the company would ever retire B2H before 100 years is extremely low. High voltage transmission lines are designed to operate in perpetuity, and the company couldn't find any example of a 500 kV line that was ever decommissioned. Additionally, it's well understood that one of the most daunting challenges to achieving the greenhouse gas reductions required of Oregon's electric utilities is the need to significantly increase, close to doubling, the amount of transmission capacity that we have. Given the urgent need for this capacity, it's hard to imagine that B2H would be retired before the end of its useful life. And finally, even in the unlikely scenario that the line did need to be conditioned, it's highly unlikely that the company would default on its decommissioning obligations, given its financial strength and its status as a public utility that's been in existence for 100 years. And I do want to briefly mention, Ms. Gilbert points to the fact that the council did not allow a phased-in approach for the Bake Oven solar project. But that decision isn't on point because Bake Oven wasn't similarly situated, as was pointed out by the hearing officer. Specifically, in that order, the council stated that the developer is an independent power producer and not a public utility, which would have access to rate recovery authorization from the state PUC to dismantle and restore a facility. For those reasons, we ask you to adopt the hearing officer's recommendation to adopt a phased-in approach. Thank you.
Hey, Ms. Rappner, any questions from council? Councilor Condon?
Member Condon, thank you for being here today for so long, and something tells me the next few days. Just a question for you. As you have done transmission lines in other states, and I think I'm allowed to ask this. Do you have security instruments on any of your transmission lines?
So
before we do answer this question, we do need to stick to what is already in the evidentiary record. If I don't have the full record in front of me right now, so I can't, completely assure that that's the case, but I would ask that we do stick to what's in the record.
And I am really sorry, but there is nothing in the record on that question.
All right. Thank you very much.
Thank you, Ms. Rappner.
Thank you.
If I may, I'll quickly share the department's position with regard to this contested case issue. Patrick Rowe with the Department of Justice. Don't want to repeat too much. We do, as Ms. Rackner stated, we disagree with Ms. Gilbert's position that that council is bound to require a bonding more than what has been proposed. As Ms. Rackner pointed out, the rule gives council discretion. It's essentially what council finds to be satisfactory to comply with the standard or to provide assurance. The department believes that the proposed gradual increase of financial assurance is appropriate because it recognizes the low risk that the proposed facility would be retired in the first several decades of operation and the low risk that the applicant would not be able to pay for decommissioning and restoration if it were to be retired early. This facility is distinct from other energy facilities that come before council for the reasons that Ms. Rackner noted. It is not just an energy facility. It's a transmission line being proposed by a utility with a long history of operation and an ability to recover costs from ratepayers if necessary. A couple comments that Ms. Gilbert made in her oral testimony. She referenced, and it might have kind of slipped through, that council is precluded from applying a balancing determination to the retirement and financial assurance standard. That is correct, and I'll remind council what the balancing determination is. The balancing determination says that if an applicant comes to the Department of Council and says, we don't think we can meet this particular standard, they can ask council to apply a balancing determination and assess whether the overall public benefits of the proposal outweigh the adverse effect on the resource that's protected by the standard. So for example, if it was the Fish and Wildlife Standard, they say we can't meet that. Well, council could to balance and say, well, do the benefits of this proposed facility outweigh the impacts on fish and wildlife? That's not happening here. The applicant has not said they can't meet the standard, and the department has not applied a balancing determination to this standard. Ms. Gilbert also mentioned court decisions that say council is prevented from waiving requirements. Again, that's not what's happening here. The department is not recommending that council waive the retirement and financial assurance standard. It's to the contrary. The department has recommended how council can find compliance with the standard. See, I'm running low on time, so that's all I have for now. Thank you.
Any questions? Councilor Condon?
Councilmember Condon for the record. Mr. Rowe, I think this question is appropriate. In the material, the cost to ratepayers is included. And as far as FSEC is concerned, that does not come under our purview, or it's not within our jurisdiction how much it's going to cost ratepayers. Is that correct?
That's correct. That's a Public Utility Commission issue.
Yeah. Thank you.
So.
Okay, so once again, now that we've heard from everyone, you are free to ask me any questions that you might want to in terms of legal issues, and otherwise, this is open for deliberation.
Hanley.
Ms. Condon?
Condon, as far as the contested case is concerned, I don't have any questions or concerns about that, but I do have some concerns about the proposed order. And so are we going to wait? We want to wait for that discussion, or?
Excuse me, for the record, Todd Cornett. So we can either consolidate and make one sort of straw poll like I talked originally, but if you're concluded that you have, you agree with the hearing officer on the proposed contested case order and you just want to deal with that straw poll right now, we can deal with that and then you can move back to the proposed order. It is entirely your choice.
It'd be nice to check that off.
Okay. So
I don't have any objections to the contested case order. Mrs. Hanley.
It's Councilmember Condon for the record. Thank you. The contested case order is taking into consideration the proposed order as we see it, right? I mean, the administrative law judge has made a decision on the contested cases. I don't have any issues with that. So as long as it doesn't touch, as long as we have an opportunity to question the proposed order, I'm good to go.
Okay. So you want me to call the straw poll? Okay. So I have the council agrees with the findings of fact, conclusions of law, and conditions of approval in the proposed contested case order pertaining to issue RFA 1. And if that sounds good, I will call Cindy Condon,
Yes.
Jordan Truitt,
Yes.
Ann Byer,
Yes.
Hanley Jenkins,
Yes.
Harry Chalktoot,
Yes.
Ken Howe.
Yes.
Thank you.
So we're back now to the proposed order on retirement and financial assurance, standard 1. So counselors have comments. Counselor Condon?
And I'm Kellen Tardyweather here. I'm passing the ball, and I'm, to the extent there's a little bit of lag, but I'm trying to pull it up here.
Excuse me, this is the court reporter.
Sorry.
Yes, Chris.
Yeah, I wasn't sure if Councilmember Condon was saying anything because everybody was muted.
Okay, thank you.
yeah.
What was the last thing you have recorded?
Well, it said, so counselors have comments, and then it went to you. So I'm saying if Ms. Or Councilmember Condon said anything, it was not recorded.
Thank you. This is Councilmember Condon, and I will repeat it. I would like to turn the attention to recommended retirement and financial assurance condition 5, and I think it's now brought up on the screen. With respect to that, I think as we've discussed, this project is very different than some of the others we've discussed in the past. But I also think that 50 years is a very long time, and obviously 100 years is even longer. And I question the $1 for the first 50 years. This is a changing industry, and I think we're going to see more change in the next 20 years than we've seen in the last 70. And so from a financial perspective, it strikes me that we, by conditioning this project, as we have suggested here, we are putting Oregon taxpayers as the backstop should something happen. It might not be likely, but it could happen. And certainly given the changes in energy per generation, just everything that's going on in energy. And what I would like to see here right now, the added language in red in the document is the department shall review the 5-year report. So Idaho Power would be obligated to do a 5-year report. And I would like the report to be annual, and or I'd like to see it as an annual report. And in addition, that or at any time required by the council. Should something happen, wildfire, bankruptcy, some event that would cause us concern in terms of the conditions we put on, that they obligate taxpayers of the state to be that backstop, I'm uncomfortable. So I would like us to retain the ability to always come back and say we need a bond to speak to the risk.
Cindy, I'm not clear on what you're asking. Are you asking that the 5-year be changed to 1 year?
That's what I'd like to see, an annual report. I'm pretty sure that a public company has to do an annual financial report, and I don't think that would be a burden to the organization. But additionally, that we would have the right at any time to require information, and should that information suggest more risk than we had intention of here, that we could require additional security at any time.
Chair, this is Perry Chalktooth. And for the record, a $1 bond, it just doesn't seem practical to me that something on this level of cost and this level of making profit, that a dollar is kind of strange. I hope I'm able to talk about it. Sorry if I'm not.
Any other council discussion? Where's the rest of the council on Councilor Condon's suggestion?
Can I ask a clarification? This Kellen Tardy Weather, can I ask a clarification question? So making it annual and then, or at any time council requests, was that specific to the information that is specified in this report? Or are you saying that you want a different information? The examples you gave of like fire or risk that may increase the bond amount, that those are kind of out of the scope of what was covered in this 5-year report. When council reviewed, and when we discussed this at the review of the DPO, like you on your onset of your comments of just like, well, technology changes. We want to know what's happening out like it with the grid and with technology. And that's where this came from, with the 5 years being a reasonable time that maybe something would change. But I just, if with what you were asking with those examples that you gave to me, those are not, this is like technology and those are like risk things.
Yeah, those weren't examples for me of information. It's financial information. What we're doing is saying you don't have to provide security. This is Councilmember Condon for the record. Security. We're willing to take that risk ourselves. And I'm uncomfortable with our doing that. It's not us, it's the taxpayers of the state of Oregon. And it's a financial report that would tell us, I mean, I quite frankly, I'm not really sure what's intended here by a 5-year report. Financial, I thought that to be a financial report, and maybe you were thinking just very differently. I mean, as I read it, I was thinking financial report.
Well, it's like this is it's the physical condition of the facility, evolving transmission or electrical technologies, the facility's performance in the context of the larger power grid, certificate holders, general financial condition, including the certificate holders' credit rating at that time.
Yeah. It's the financial report I'm focused on.
Right.
In the end, it's their financial ability to do what we want them to do for retirement and giving us the financial assurance. And I don't see financial assurance here. So other than that they're a regulated utility and have been in business for 100 years, there are risks that we may not have any idea of what those will be.
So this is Hanley, and the burden really here is, I mean, the information is being provided by the Idaho Power, but the burden is on the department to evaluate that 5-year plan and include any other additional information as it's listed here in order to do that. So I'm not uncomfortable with the information that's being provided because I think it does the certificate holder's general financial condition, and the department is evaluating that as a part of that report that they received from Idaho Power. I'm not sure that it's necessary every year. That's, I guess, is my concern. It's
Everyone's muted again.
Scroll it so I can see this, the addition.
Thanks, Todd. Yeah, there's just a little bit of a lag here, so I'm just trying to pull it up. Do you mean that's right here, right there? Okay.
So I guess my concern is we are talking about a transmission line. We're not talking about the solar facility or turbines. And we have no examples. Our testimony is there are no transmission lines that have been taken down. And at least from what I'm seeing here, I think what is being required in the report and by the department's evaluation every 5 years is adequate.
The record, Todd Cornett. And the reason I want to scroll through so you can see the full condition on the screen is it does come to council. So it's not just the staff's review, it's the staff's review, and then the council will consider whether the bond is required at that point in time. So it's not just us, it is council. Ultimately we're making our recommendation to you, but you make the decision at that point in time, whether it's every 5 years or if you want to change it to some other frequency.
Right. And just in response to that, this is Councilmember Condon. 5 years is a long time when things go wrong. And so 5 years, if we want to keep the 5 years, that's fine. As long as I would like to see something that says we have the opportunity at any time to ask for financial for this information and make decisions accordingly. Not really asking for anything up front for a pretty large project. And I would like to see us as having flexibility to analyze the situation as situation changes.
So it's proposed at 5 years now.
Right.
And Councilor Condon's suggesting that stay the same, I guess, at 5 years, or anytime if the council were to deem necessary to have it other than at the 5-year interval. Where's the council on that?
So you do it after that first underlined sentence. Ian. Or at any time requested by the department. I don't have a problem with that. This is Hanley. I don't have a problem with that.
Other councilors?
This is Jordan. Cindy, are you asking for the complete report at any time or just the financial report upon request, financial condition?
Well, I would say the complete report, because we'd be trying to make a decision based on a changing set of circumstances. Top foremost in my mind is the financial piece.
Would there be an event that would trigger that or just at random upon request?
Wish I were smart enough to project what all of the instances are, but there certainly are instances we've seen in the last 5 years that have impacted transmission lines, power generators. So.
Other council members want to let us know your support or not of this proposal?
Chair Howe, this is Ann Byer for the record. I'm torn on this because I think it's reasonable to have the big bond during construction and then to have a lesser bond during initial operation. I like that there's the kick in at 50 years, but it is a changing world, and having the ability to adjust the bonding. And I understand Idaho Power's position, and they need some certainty because they have to go in and ask for rates, but making sure that they maintain their financial health. And it doesn't strike me that this council is going to ask for information just for the sake of having another report to review. It would be some changing circumstance that would trigger that request. So I'm supportive of that additional language, suggesting that the department or the council can request that the specific information as necessary or when needed.
Councilor Truitt.
I'm torn as well. I'm comfortable with 5 years. I don't want to necessarily, Councilmember Condon, I understand completely where you're coming from, but I also don't want to arbitrarily, maybe it's not arbitrary, but on unforeseen events, open the door to what could turn into annual reports on request. It's a burden on both sides of the equation. I think there should be some sort of qualifier potentially in there. But again, I'm torn on it.
Councilor Choptuk.
I'm also torn on it too, but we have no way of knowing what the future brings. It might be enough just to put in the wording that upon request, we get the report upon request.
Vice Chair Hal, if I
Yeah.
don't want to overstep here, but I may have a suggestion that is from contract language that because I think I've heard the concern expressed that we don't want a future council to act arbitrarily. Now, ordinarily, there are legal protections against doing that in, your kind of administrative exercise. This is the way that the statutes that govern siting work. There's this concept that the site certificate is a contract. And so it binds the council just as much as it binds the applicant. If there is a concern about a future council acting arbitrarily, well, because you've put in kind of carte blanche to request a report wherever, whenever, a typical thing that you'll see in contract language is just as, the council may reasonably require, that there's some kind of concept that you can't just ask for this just because you need to have a stated basis for it. And that would, put things more in line with the notion of how the council has to conduct itself in, its regular decision making, that even when you have discretion, you don't have discretion to be arbitrary. You have to provide reasons for what you're doing. So because you're right, you can't predict all potential future circumstances in which, with hindsight, you might want to see a piece of information. And so that's a tool that we'll sometimes use to try to hedge against that is provide some comfort to the other party that we're not just going to ask for it for fun, which I can't imagine anyone doing anyway. But that you still have the ability to get the information if you need it.
Thank you. With that, I think I'm on board too. So I think there's a consensus there that this language would work. Do you want to do a straw poll.
Or I can at least read what I have and you can kind of give me the head nod if that sounds good, and then I'll call the vote, or you can make a change. So what I have is agree with the findings of fact, conclusions of law, excuse me, and conditions of approval in the proposed order pertaining to the retirement and financial assurance standard that are not related to the issues in the contested case with the following modifications associated with condition 5. And sort of preface, this is not one where we need the actual specific language. I think there's enough in here where we have the purpose. So that would be to change to require a complete report at any time the council, quote unquote, reasonably requires, in addition to the 5-year frequency. And we can come up with language of how to insert that appropriately if that's where the council wants to go.
Member Condon here, and that works for me.
OJ, my understanding, Councilmember Condon, was that you were asking that council be allowed not just to require them to provide the report, but also potentially revise the financial assurance that is required if the information provided in the report causes you concern. Is that correct?
Isn't that already included?
Okay, sorry. Thank
in
you.
Language?
It's part of the report.
Yeah. Thank you. Part of the right of the council. Yeah.
Yeah, as kind of scrolling up, that would be the follow-up if the council deems it appropriate and necessary. Would be to require the full bond or some other amount at that point in time based upon the report and their evaluation.
The Councilmember Condon here, the last sentence on page 303, the certificate holder shall be subject to council's determination.
So if that sounds appropriate, then I can read. Cindy Condon,
Yes.
Ken Howe,
Yes.
Jordan Truitt,
Yes.
Perry Chalktoot,
Yes.
Ann Byer,
Yes.
Hanley Jenkins.
Yes.
Thank you, council members.
Okay, we're now to threatened and endangered species standard T&E 1. It's 8:15. Do we want to continue or try to get this one done?
So certainly at the discretion of the council, I think we need to get
Okay.
through the ones that are on the list for tonight.
Okay, let's go.
Again, we will not be able to get through all of these unless we kind of get through them. So
Yeah.
we really need to get through them.
Council Secretary, that was just through soil protection, so T&E and soil protection, but not the tentative need ones. Yeah, okay.
Okay, let rock and roll. For the record, Kellen Tardyweather, Oregon Department of Energy. Nancy's pulling up our PowerPoint here. We're going to move on to the council's threatened and endangered species standard. I'm just going to jump in here. Council is familiar with this standard. I'm going to say that it's a little bit more of a straightforward standard, which for plant species, it says that we've evaluated and addresses impacts to plant species that are identified as threatened or endangered by the Oregon Department of Agriculture. And for animal species, it would be the same for animals identified by ODF&W as threatened or endangered. So that is the scope of council's jurisdiction underneath this standard. There is overlap with federally listed species in between Oregon. However, it is a different list. So the council's the T&E, I'm going to call it T&E, threatened and endangered standard, and council's fish and wildlife habitat standard don't implement federal requirements. There's not a council standard authorizing the council to impose or enforce the federal regulations. ODF&W could, and when I say ODF&W, that's the Oregon Department of Fish and Wildlife, could make recommendations under the fish and habitat under their mitigation policy, excuse me, based on information about federally listed species. However, the council doesn't have that, the jurisdiction to, enforce those federal regulations. However, all applicants are required to also comply with federal requirements. So there is that dual jurisdiction there. The analysis area for threatened and endangered species is a half mile from the site boundary and a half mile. That's the area that is evaluated to look at. Next slide, Nancy, please. Let's see, I have a couple tables referenced here. There were field surveys that were conducted to evaluate threatened and endangered species, along with desktop and other studies to evaluate threatened and endangered species. I'm sorry, it's kidding. I'll get into it here. And then I have a little snippet from table TE2, and this table naming is from the proposed order, and those are the page numbers for these. These are the three, it's a little bit hard to see there, but there's three threatened and endangered species potentially in existence and potentially impacted by the facility. One is the wolverine, Washington ground squirrels or WAGs, and then Snake River summer Chinook salmon. The next slide, please. So let's see, we have the WAGs. I had mentioned those on the onset. Those it's a specific area where there is WAGs habitat. WAGs habitat is category 1 according to ODF and W. That is an avoidance measure. So there are your avoid impacts. There's no mitigating impacts to those. So your threatened and endangered species condition 1 is the avoidance of the WAGs habitat. And then there's specific definitions of that types of habitat for them. And then there's also condition 2, which imposes buffers to certain threatened and endangered plant and animal species. And then I have this recommended fish and wildlife condition 16 under here, which is, again, this is like interrelated conditions. We love those. But really it's here because it makes sense, right? Under Fish and Wildlife Habitat Standard, we have conditions that say, hey, go out and do these surveys according to these protocols. It's a survey condition. And so you may as well bundle all of your species that you're surveying for under one survey condition according to certain survey protocols. So that's this condition here. The little dots there is this does also include plant species, but Jesse's going to talk about the plant species. Did you have anything you wanted to add? No. And that is that.
Thank you. Mr. Ratcliffe.
Thank you, Vice Chair Howe. So we have one issue under threatened and endangered species that has an exception that was filed by Ms. Gear. The issue is, and I guess if we could go one slide forward, I think that'll do it. There we go. Whether the applicant was required to have an Oregon Department of Agriculture botanist review the application for site certificate. And so the hearing officer's opinion on that issue was to note the part of the rule that's applicable here from the council's Division 22, which requires that the council consult with appropriate state agencies on the evaluation of impacts and mitigation to threatened and endangered species. The hearing officer ruled that consultation is not defined in the FSEC rules, but based on dictionary definitions, consult is ordinarily understood to mean the act of asking for advice or opinion of someone. The standard does not require that the department or the applicant demonstrate that a Department of Agriculture botanist from the Native Plant Conservation Program review the site certificate during every phase of the process. It simply requires consultation during the process. Further, she found that the Department of Agriculture is a reviewing agency and received notice of the preliminary application for site certificate, the amended preliminary application for site certificate, and the complete application for site certificate. The Department of Agriculture submitted comments on the preliminary application for site certificate, and ODA botanist Rebecca Curran provided comments in April 2014 concerning threatened and endangered plant species and mitigation options. So again, that's the council's ruling, and I believe because Wally is here at the table, that means we have a recording of Ms. Gear's oral argument on this issue.
I think that's very high tech. Work. So just for the court reporter's benefit, if you have any trouble hearing this, just interrupt and let us know, but this should work. That's a good point.
Susan Gear, issue TE1. I'm a botanist in plant community ecology specializing in rare plants and monitoring plant communities for nearly 30 years. I request that the council deny the site certificate or remand to the judge for more evidence and a new proposed contested case order, and to Odo for updated analysis with the current threatened and endangered plant list and current proposed routes. Exception 1. Judge Webster erred by concluding that the consultation about Oregon's rare plants does not need to involve the Native Plant Conservation Program, hereafter the Rare Plant Program. A rare plant botanist representing the state of Oregon should review and comment on the final ASC. The proposed routes on federal land were reviewed by federal agency botanists, but the routes on the other ownerships, private, city, and county, did not receive the same level of review. Please read my responses to motions for summary determination. Exception 2. Judge Webster erred in the summary determination by finding a 2013 comment in a 2014 meeting between Odo and ODA's rare plant botanist was sufficient consultation. Judge Webster misstates a legal issue in the proposed contested case order. State law requires the council to consult with appropriate state agencies. Judge Webster reasons that Odo was acting for the council when it mailed notifications and received a comment in 2013 and thus met requirements. Rather than whether Odo met cursory requirements, the real issue is whether the council is fully informed of the effects of the facility on T&E plant species as required by state law. Information used by the rare plant botanist in her comments was 5 years prior to the 2018 filing of the final ASC and prior to the time that the current routes were proposed. Odo made no effort to notify the ODA of the current routes. The 2014 meeting was not meant to be a final consultation. The amended proposed ASC was still under development. Meeting notes show that the rare plant botanist expected further involvement, and they state that if the rare plant botanist is unable to respond for lack of resources, Odo has a compensation agreement with ODA. Nonetheless, funding ended, and there was no program for several years. Thus, ODA was not an effective reviewing agency. The council should use the current T&E plant list. ODA's original list is from 1988. By law, that would be reviewed every 5 years, yet it has never been updated. There have been attempts to fund updates. Native Plant Society of Oregon successfully petitioned the state legislature for those funds in 2017 and 2021. There are now recommended updates. The Rare Plant Program expects to adopt them in 2023. The recommended list contains species which would be impacted by B2H, and they deserve protection. Judge Webster mistakenly states that I offer no material evidence of rare species in more recently proposed routes. 2 species on the list are found on Glass Hill and would be impacted: Trifolium douglasii and potential occurrences of Pyrrhicoma staberula. The council should conduct a full review of the current proposed routes and consult with ODA's Rare Plant Program using the updated recommended T&E list.
Thank you. Good evening, council members. My name is Jocelyn Pease for Idaho Power Company. In Ms. Gear's first exception to TE1, she challenges the hearing officer's ruling on summary determination that the council is not required to consult with the Native Plants Conservation Program, or NPCP, and that the consultation with the Oregon Department of Agriculture was adequate for purposes of meeting the threatened and endangered species standard. The standard provides for consultation with appropriate state agencies and in connection with threatened and endangered plants includes references to the Oregon Department of Agriculture. Neither the FSEC statutes nor the FSEC rules further define the term appropriate state agencies or include any specific reference to the NPCP. Idaho Power complied with all requirements to allow the Oregon Department of Agriculture, which oversees the NPCP, an opportunity to review and provide comments on the ASC. However, Idaho Power is not required to solicit comments specifically from the NPCP because the NPCP is not a reviewing agency for purposes of FSEC's application distribution rules or an appropriate state agency for purposes of the threatened and endangered species standard. Instead, the appropriate state agency is ODA, and the record demonstrates that ODA was provided the opportunity to review and comment on each iteration of the ASC. In Ms. Gear's second exception to TE1, she challenges the hearing officer's ruling on summary determination that ODA's 2013 comments and 2014 meeting with ODO were sufficient consultation. Ms. Gear asserts that further consultation was necessary, but the record demonstrates that Idaho Power and ODO provided to ODA copies of each iteration of the ASC and thereby gave ODA an opportunity to comment. ODA therefore had additional opportunities to provide comment on these topics. While the department rules do not define consultation, the hearing officer concluded that the term is ordinarily understood to mean the act of asking for advice or opinion of someone. This definition is also supported by Oregon case law, and the Oregon Court of Appeals has concluded that when consult is not defined by statute, an agency satisfies that obligation by inviting other parties to comment. Relying on that common definition, ODO complied with its consultation obligations by inviting ODA to comment. Ms. Gear also argues that ODA lacked funding to review the ASC, but didn't provide any evidence in the record to support this assertion. Moreover, ODO informed ODA that there was an existing compensation agreement between the agencies, and therefore ODA staff could be reimbursed at any time for any time spent reviewing the ASC. Thus, there's no evidence in the record that ODA ever sought reimbursement, and Ms. Gear's assertions that ODO failed to provide funding to ODA to review the ASC is not supported by evidence in the record. Ms. Gear raises additional arguments that FSEC should consider alternative lists of rare plants. However, these arguments are clearly outside the scope of issue TE1, and moreover are inconsistent with the plain text of the Threatened and Endangered Species Standard, which requires FSEC to assess the plant species that ODA has listed in accordance with ODA's rules. In particular, OAR 603-073-0070. Based on the foregoing, Idaho Power respectfully requests that the council affirm the hearing officer's ruling on TE1.
Thank you, Ms. Pease. Does the council have any questions? Didn't look like it. Thank you.
Patrick Rowe, Department of Justice, on behalf of the Department of Energy. We agree with the comments that Ms. Pease just made. In addition to those comments, the department would point out that there are certain conditions, recommended conditions that the department has recommended that would involve the ODA Native Plant Conservation Program to conduct a review. The department would point council out to Fish and Wildlife Habitat Condition 1. That's the reclamation, which requires the reclamation and revegetation plan. That condition has a formal reviewing agency process built in to finalization of that plan as a pre-construction requirement. It would require that Idaho Power evaluate specific vegetation, including threatened and endangered species. And that would ensure that if there were to be any impacts to TNE plant species, ODA, including ODA's Native Plant Conservation Program, would have the opportunity to weigh in and concur on level of impact, avoidance, and necessary mitigation. Also, land use condition 14, the ag mitigation plan, would also evaluate sensitive resources such as threatened and endangered plant species that are present within private EFU lands. So those additional conditions, we just wanted to call to your attention to make sure you understand that this doesn't mean that ODA's Native Plant Conservation Program isn't going to continue to be involved.
Any questions from council? Okay. Council Ratcliffe.
Yeah, so once again, we've had the overview of the threatened endangered species standard provided by Kellen, and that's all that we have in terms of this particular issue. And so now's the chance for council to deliberate or ask any questions you might have of me.
Okay, comments from council. Councilor Condon.
Thank you, Councilmember Condon. I was a little bit concerned about the timing involved here with the consultation in 2013, 2014 versus the date of the application. Was there, is that typical, or was there another attempt other than just sending the application to ODA? Was there any other communication with ODA?
Yes, so the applicant, I believe this is summarized in the proposed order, kind of did in-person outreach, and there was meetings in the original PASC, which is 2013. And then I would have to go back and, look at the record to confirm on whether or not in between that gap, because basically the project kind of got put on pause, and amended preliminary one submitted in 2017. But at that time, then we did go back out for comments. There was kind of a communication or a staffing gap with ODA at that time. We didn't really have somebody that would, so they didn't respond. So it was hard to get, we can't, and in our memos that we send out to reviewing agencies, we do include a portion that says if you don't provide comments, we assume that you're okay with the information. We tried, but they didn't provide comments.
Thank you.
Okay, is council then at the point that, see if I have this right, that the hearings official exception decision stands as is, and the proposed order stands? And the contested case order, both of them.
In this instance, excuse me, in this instance, I could do a consolidated straw poll if that was acceptable.
This is a good one to do it on, I think.
Okay, so I will read the potential and you can tell me if you agree. So agree with the findings of fact, conclusions of law, and conditions of approval in the proposed order pertaining to the threatened endangered species standard that are not related to the issues in the contested case and in the proposed contested case order pertaining to issue TE1.
Yep. Okay. Works.
Okay. Kent Howe.
Yes.
Ann Byer. Hanley Jenkins.
Yes.
Jordan Truitt.
Yes.
Perry Chalktoot.
Yes.
Cindy Condon.
Yes.
Thank you, council members.
Okay, we set a record on that one. There's the soil protection.
For the record, Kellen Tardyweather. Going to go over the soil protection standard. I have the language of the standard up here on the screen. This is a little bit more of a straightforward standard, as we like to say, but nothing is ever really that way. But it's task council with finding that the applicant can design, construct, and operate the facility, taking into account mitigation, that it's not likely to result in significant adverse impacts to soil. Now, here I'm going to just kind of highlight, and we have some things listed. We have erosion, and I'm just going to kind of skip over and then say chemical spills. right? Those are kind of the big ones that we're going to talk about that the proposed order and the ASC talks about. But it does also say including but not limited to, meaning that it could talk about other things. I do want to point out that the language here for the standard does correspond with the information requirement under Division 21. So the application requirements say, hey, provide information about these things listed. And so that's what is generally provided. However, in this application, it's Exhibit I. There is a wealth of information because it's a long facility and there's lots of soil types, et cetera. The temporary impacts to soil are about 4,300 acres, and then the permanent impacts are about 757 acres. The temporary impacts are impacts that are associated. Next slide, please, Nancy. That are associated with construction. We're kind of familiar with talking about that. So these are temporary roads, the multi-use areas, the pulling and tensioning sites, and the activities that would impact soils are the clearing and grubbing, the grading, vehicle compaction from going in and driving on these roads. So the areas temporarily impacted associated with the construction of the facility in restoration would have to be decompacted and revegetated, and there are conditions that address both of those. The permanent impacts to soils are kind of make sense. They are like the permanent tower structure, the permanent infrastructure on the ground, are those permanent impacts. And then next slide, this is just, I have a map here. There's a very large map set that maps out all of the soils. The analysis area for soil protection is just the area within the site boundary. So that's what you would see on those map sets. So there's several soil protection conditions. We kind of inadvertently rerouted to one that we talked about earlier under structure. Again, I'm just pulling and highlighting some conditions, but there are more than what I'm pulling out in here. The staff report summarizes them too, but there's more conditions than what we're providing, but we could talk about anything. But soil protection condition 1, council's probably used to seeing this condition. This is that prior to construction, the applicant will obtain and provide to the department the NIPDES permit, the National Pollution Discharge Elimination System, 1200C general construction permit. Typical of that permit or required in that permit is an erosion sediment control plan. So this is a federally delegated permit that is not a permit that council's making a decision on, but we, the department, request and use this information to demonstrate compliance underneath the soil protection standard. And a lot of it is that erosion and sediment control plan, because that has those best management practices, the BMPs, about how the applicant's going to reduce runoff, soil erosion, dust control, et cetera. And then up on the slide here, I have the soil protection condition 5, which has that the certificate holder shall inspect the facility components for impacts as part of its regular transmission line inspections, which this is more of the operational aspect of addressing impacts to soils. And that's what I have. Do you want to add anything? Okay.
Okay, so thank you, Callan. So we have one issue under soil protection that was raised by Dr. Foudy. She filed exceptions. And great. And the issue is whether the soil protection standard and general standard of review require an evaluation of soil compaction, loss of soil structure and infiltration, and loss of stored carbon in the soil and loss of soil productivity as a result of the release of stored carbon in soils. The hearing officer's opinion talked about the structure of the standard language and the use of the phrase that Kellen had mentioned, the including but not limited to language, and read that to say that there are certain enumerated things, and again, those appear in the council's Division 21 application rules as well, in terms of what needs to be submitted for a complete application, that are specifically enumerated. So we have the erosion, deposition, application of chemical substances. But the hearing officer's view was that the included but not limited to doesn't necessarily require that an application for site certificate evaluate things that are perhaps of a different kind than the list had provided. So the issues raised by Dr. Foudy, including the soil compaction and structure, et cetera. The hearing officer also ruled that neither the application for site certificate content rule nor the standard itself require that the applicant use a specific methodology to evaluate soil types or characteristics, nor require a presentation of the highest level of detail from the most current sources. The standard does not require the applicant to establish a specific time frame for restoration or recovery. Idaho Power correctly evaluated soil types within the analysis area and evaluated impacts based on potential locations of temporary and permanent disturbance. Then, in response to the issue as it was initially presented by Dr. Foudy and then supported by her arguments, Idaho Power during the contested case provided an updated table that presented soil information by county with the soil order, ID, name, acreage, percent, and acreage of disturbance area and soil properties. Soil protection conditions 2 and 3 would minimize erosion and spill impacts during construction. The fish and wildlife habitat conditions would also ensure that temporary soil impacts are restored post-construction through revegetation and noxious weed control within a reasonable time frame to as close to pre-disturbance conditions as possible. So that's the issue as it was framed in the contested case and the hearing officer's ruling. And so now is the time for Dr. Foudy to provide oral argument. Okay.
All right, my name's Carl Anuda. I represent Stop B2H. And for purposes of tonight, I'm assisting Dr. Foudy also. Stop B2H concurred in Dr. Foudy's materials and her presentations. And so I'm going to cover both her materials and Stop's concurrence and do so briefly, and then hopefully answer any questions you might have. I'm going to start with the key points, which are that the proposed contested case order omitted any findings related to dynamic soil property changes. There's a lot of data put in about erosion, but that's not the only impact. Compaction, dynamic soil makes a huge difference. In addition, the administrative law judge made an evidentiary ruling at the end of the process where she improperly excluded documents that should have been in the record. Those are both fundamental errors in our view. Dr. Foudy is a PhD. She's a soil specialist and a hydrologist, and she lives here in New Grand. She knows her materials. Her testimony was that IPC had failed to examine the impacts from the proposed facility in sufficient detail. She used best available science in her presentation. Her testimony was, in our view, and if you listen to the recordings, I think you would agree, never really credibly rebutted. When Dr. Foudy outlined in her closing remarks the fact that there was a host of failures by IPC's expert, in particular to address some of the basic documents that IPC's own expert relied on, IPC asked that those documents be stricken from the record. The ALJ mistakenly agreed, and as a result gave less weight to Dr. Foudy's testimony. Any document that IPC and its experts used should have been part of the record, because without that, the applicant could claim anything was true and the public wouldn't have the opportunity, and this council wouldn't have the opportunity to review materials and determine if they agreed. Dr. Foudy outlined how IPC had failed to demonstrate compliance with the standard. There was a lot of discussion about how and the condition you saw a few minutes ago on SP1 was that the department was relying on the NPDES permit from DEQ. That permit, as was outlined by Dr. Foudy, only addresses erosion. It does not address compaction. It does not address dynamic soil changes. It does not address any of those other issues. Reliance on that is inadequate. There were a number of fundamental problems with the IPC analysis. I encourage you to read Dr. Foudy's exceptions. They're very detailed and very scientific. And thank you, Secretary Cornett. I was going to point out that I'm using both her time and mine. Dr. Foudy also outlined how the proposed mitigations by IPC were not consistent with the stated goals. They weren't peer reviewed and they didn't follow the literature. She noted that IPC used the wrong NRC soil database and that resulted in planning level analysis rather than project level analysis. That's important when you're doing mitigation. IPC used the wrong analysis for soil impacts because it used a larger soil boundary rather than a smaller soil impact area, thus incorrectly minimizing the nature or the magnitude of the soil's impacts. IPC misrepresented the longevity of this soil impact by stating that the impacts would be temporary and then defining temporary as the life of the project, which you all have already heard is forever. Not what most of us would consider a temporary impact. She also noted that IPC failed to provide a soils restoration plan, instead relied on vegetation restoration plan as a proxy for soil productivity. IPC also failed to identify major soil types in the analysis area, incorrectly discussed the soil order, the broad highest level soil category, and they failed to identify all current land uses on productive soils. That's also important. The fundamental problem here is that Dr. Foudy's testimony should have been given more weight. The hearings officer disregarded some of the literature she cited, and we think that this, under the circumstances, should motivate this council to send this issue back for further analysis by the administrative law judge and a further hearing on these detailed scientific issues. I'm happy to answer any questions if you have any.
Thank you, Carl. I didn't get your last name.
Anuta.
Anuta. Any questions of Mr. Anuta? Okay, thank you.
Thank you. Again, this is Jocelyn Pease for Idaho Power for the record. Dr. Foudy raised many issues in her exceptions filing, and Idaho Power fully addressed these issues in its responsive briefing. I'll just focus on several of the key arguments that Dr. Foudy had made in her exceptions filing and attempt to address in the short time a number of the issues that Mr. Anuta had also raised. First, in her exceptions filing, Dr. Foudy argues that Idaho Power should have addressed additional soil properties in its analysis regarding the soil protection standard. In support of this argument, Dr. Foudy emphasized language in the standard regarding impacts to soils, including but not limited to erosion and chemical factors such as salt deposition from cooling towers, land application of liquid effluent, and chemical spills. Dr. Foudy urges that the council should read the phrase including but not limited to expansively. However, Idaho Power explained in its briefing that when applying Oregon principles of statutory interpretation to discern the intent behind the regulation, it is clear that the scope of the standard is limited to the common characteristic between the specific examples in the standard. Consequently, the general term impact to soils must be interpreted considering the commonality between the specific terms of the regulation. And this was a point that Mr. Ratcliffe had also pointed out in his remarks. On the other hand, in her analysis, Dr. Foudy had provided no legal basis for her interpretation of the soil protection standard. Instead, it is simply to satisfy her opinion that the soil properties listed in her issue statement are necessary to satisfy the standard. Furthermore, Dr. Foudy's request to evaluate additional soil properties is essentially an academic exercise. Idaho Power's expert witness addressed this issue during cross-examination, explaining at length that Dr. Foudy's requests are not consistent with industry standards and that Idaho Power and others are not expected to perform the academic research project level of analysis that Dr. Foudy demands, but rather the project evaluation must conform to industry standards, which rely on agency-issued guidance documents and best management practices, or BMPs. Second, Dr. Foudy claims that Idaho Power's analysis was not sufficiently granular. However, there is no evidence in the record that supports Dr. Foudy's claim that compliance with the soil protection standard requires a more granular analysis, or that a more granular analysis would result in any new or different mitigation measures or BMPs to achieve compliance with the standard. And in fact, the level of data that Idaho Power provided is consistent with the other applications that have come before the council. Contrary to Dr. Foudy's assertions, Idaho Power committed to performing mitigation in connection with potential impact to soils. Idaho Power will conduct construction activities in accordance with Oregon environmental laws and permits, including the Erosion and Sediment Control Plan that accompanies the ODEQ issued 1200C permit and the Reclamation and Revegetation Plan, which will be reviewed by the Oregon Department of Agriculture and the Oregon Department of Fish and Wildlife. Idaho Power will work closely with these agencies during the preparation and implementation of these plans. Now, in response to Mr. Anuta's assertion that the analysis had failed to adequately address dynamic soil properties like compaction, in fact, the issues around compaction are addressed through the Reclamation Plan. The Reclamation Plan provides an explanation of how Idaho Power will treat the soils following construction, which will include in some cases, ripping the soil and working to revegetate the landscape. And the best determination as to whether this mitigation will be successful will be the revegetation efforts. And Idaho Power is bound to monitor the success of those revegetation efforts, and if they aren't working, to perform adaptive management. And so those measures that are already in place will in fact ensure that mitigation is accomplished for the soils. Regarding Mr. Anuta's assertion about documents that were excluded, the way that worked was in the contested case, there's a portion that's dedicated to developing an evidentiary record, and then that record closes and there's briefing. And after the close of the evidentiary record, no one else is allowed to put more evidence into the record. It's closed. And then folks can argue the merits of the evidence on briefing. And so what Mr. Anuta is referring to is evidence or documents that Dr. Foudy had attempted to put into the record late in the proceeding after the close of the evidentiary record, and those documents were properly excluded. Thank you.
Ms. Pease, are there any questions? Okay.
Yeah. Just a few comments on behalf of the department. Patrick Rowe with the Department of Justice. The thrust of Dr. Foudy's argument seems to be that Idaho Power's application is not complete. She argues Idaho Power should have conducted, several different types of analyses that it did not, which Mr. Anuta listed and Ms. Pease also referenced. Council has rigorous requirements for approval of a site certificate, including with regard to compliance with its soil protection standard. But in making her arguments, Dr. Foudy is setting a bar for approval that is even higher than what is required in law and in council's rules. The rules in Division 21, Council's rules that govern what information must be included in an application. The rules about soils don't require analysis of the items that Dr. Foudy is suggesting. As has been discussed, the only specific items addressed in the rule are erosion and whether there are chemical factors related to operation of the facility that could adversely impact soils. Idaho Power conducted those analyses. Second, council can find, as we've discussed throughout the evening, can find compliance with one of its standards based not just on the information in an application, but also on conditions that council imposes. We have Mr. Ratcliffe and Ms. Pease referenced a couple of those conditions. I'll point them out, and I think I'm probably going to overlap at least in one or two of these with what Mr. Ratcliffe and Ms. Pease said, but would point your attention to soil protection conditions 1 and 2. Those would minimize erosion and soil impacts. Those are on pages 97 and 99 of the proposed order. And actually, I'm not going to give you the page references because there are two different ways to reference the pages, which I won't bore you with. But at any rate, soil protection conditions 1 and 2, land use condition 14, in fish and wildlife habitat conditions 1 and 3 would also ensure that temporary soil impacts are restored post-construction. That's one that I think Mr. Ratcliffe mentioned. Soil protection condition 3, that has the erosion best management practices under the 1200C, which Mr. Nuda referenced. Fish and wildlife habitat conditions 1 and 3 include very detailed pre-construction assessments, landowner consultation, ongoing treatment and monitoring during the first 5 years, and also assessment for long-term obligations. So in short, I think the 2 points that I'd like you to take away are, one, Dr. Foudy is asking for analyses that go beyond what the council's rules require, and there are conditions that the department has recommended that will address soil impacts.
Councilmember Condon, I'm curious about the 5-year. The monitoring goes for 5 years, and then what happen? What's the timing after that? Does the department?
I'm going to kick this one over to Kellen or Sarah.
So reclamation and revegetation is viewed as short term. And so it's typical to set a 5-year milestone where there's more aggressive monitoring and treatment and restoration in that first 5 years. But then for this plan under that condition at the 5-year mark, then based on evaluation of the first 5 years, they'll develop a long-term monitoring plan, and it might be different for certain areas. Everything is going to be quite specific for various segments, but so it will be a large long-term plan with different levels of monitoring depending on the success of the first 5 years.
So just to follow up on that. So because this is, or as I understand it, it's going to be constructed in phases.
Mm-hmm.
So will each of those phases have a 5-year monitoring time frame?
I guess I imagined it to be that the line would become operational at one point in time, while it might be phased in operation. I think there's going to be one point in time when the full line goes in operation that starts to trigger the operational monitoring. Now, many of these plans have construction requirements as well. So there'll be a different set of actions that are happening during construction that are really like treatment, avoidance, monitoring, control, but then that's different than restoration.
And that's during construction,
right?
Right, as opposed to when construction is finished.
Right. So many of these plans have a multi-temporal component where they have to do pre-construction assessment, construction activities, and then short and long-term monitoring.
Thank you.
Thank you, Ms. Esterson. Okay, so we're ready now to, is the council have a different, we've got the proposed order, we've got the proposed contested case order. Do we have differences on those two? Are we ready to have Todd call the roll on that?
for. So this is, well, go ahead, Cindy. Yeah, so I don't have any objections to the proposed contested case order because I believe that what was being asked of Idaho Power was beyond the industrial standard. And goal is to meet the soil protection standard. And I think with the various plans that are required under the conditions, I think that they adequately address that. So I don't have any problems with the proposed contested case order or the proposed order.
Where's the rest of the council? Any difference of opinion on that? Hearing none. Councilor Condon?
Right. Councilmember Condon, I have some concern about the most current science being used or not being used, as someone might say. And I'm sorry, I don't have it up in front of me, but is there a requirement, a condition that requires survey prior to construction? It seems like there was related to this soil protection, and it wasn't clear to me if that speaks to that most current information available or best available science. I would hope we're using the best available science and most current information. And so I'm just curious if now the project is ready, is there a survey?
I'm not sure that the standard requires that, though, Cindy.
Pardon?
I'm not sure that the standard requires that.
I'm not either. I'm wondering if it does, or if we just use any data, use any survey requirement.
For the record, Kellen Tardyweather, it's a little bit hard to see. I need to zoom it in, but I have the language, which is, it says, information from reasonably available sources regarding soil conditions and uses in the analysis area. So that's the guidance.
Is it, excuse me, is it expected that be the current, or if there's something found 10 years old?
Well, we get into, and I would have to go, maybe Sarah, Idaho Power knows what the NRCS date for those soil map sets were. We can check the date, but we might be in one of those situations where it's, since, at the time it was submitted, it was, more current, but now we've moved forward in time and there may be new soil data sets. As a side note, for those familiar with soils, the soil categorization doesn't really change that much over time. So
what I heard you say is that at the time it was submitted, it was current.
That's what we're looking. I don't.
But in the contested case proceeding, updated information was obtained from NRCS. I believe the date on it is 2021. And then a much more detailed poll of factors was also provided. That was in Idaho Power's expert witness, Mr. Madison. So, I mean, it's more data than we would normally get in an Exhibit I to evaluate potential impacts under soil.
Thank you.
Okay. I think we're ready to entertain a roll call on both the proposed order and the proposed contested case order.
Just for the record, this is Perry Chalktooth, and I hate to complicate things, but I know there was a requirement to do cultural resource surveys on the project. It was probably done years ago, but hopefully there's a caveat for doing cultural monitoring during ground disturbance, because out there on the flat, I know that there's buried cultural resources, and the anthropological record puts the existence of Native American populations pre-Mount Mazamalair, so that's 7,000 years deep. So I just wanted to bring that up. And like I said, I didn't want to complicate the issues.
Thank you, Councilmember Choctaw. And that we will talk about that underneath the historical, cultural, and archaeological resources standard tomorrow. What? You do it. Do it.
Yeah, that's correct.
Not there yet.
Excuse me. Okay, so I heard correctly, then where we're at, I'm sorry, let me clarify. It's SP1, right? Okay. So agree with the findings of fact, conclusions of law, and conditions of approval in the proposed order pertaining to the soil protection standard that are not related to issues in the contested case, and in the proposed contested case order pertaining to issue SP1.
Sounds good
Okay.
to me.
Kent Howe,
Yes.
Ann Byer, Hanley Jenkins,
Yes.
Jordan Truitt,
Yes.
Perry Chalktoot,
Yes.
Cindy Condon.
Yes.
Thank you, council members.
Well, we didn't get to the need standards, but
That was a potential.
yeah.
So we got through all the ones that we absolutely wanted to get through done tonight. So I appreciate everybody's efforts tonight. That was
Yeah.
a big pull, and I think, you know, as we talked about, trying to get the cadence, and
Right.
There'll be a little more complicated tomorrow because there are more issues for some of the standards. So, but I think you kind of got the swing of things now.
We did pretty good for only being an hour late. So,
Yeah.
okay. The time is now 9:07 p.m. and the August 29th, 30th, 31st, 2022 meeting of the Energy Facility Siting Council is now recessed until tomorrow morning at 8 a.m. Thank you.
Thank you.